Tomorrow.
What is the subject matter? Non-consideration of what is the urgency? A week. Yes, tomorrow. Tomorrow.
So put it. Effective method 4 to 8 of the day.
4 to 8.
8 of the next method to is the engaging the method. So it takes time. I prefer some sort of
4 to 8. Okay.
and if you have to
Second concept.
4 to
4 to 8. No,
for 5 to 8.
5 to 8. 5 to 8. And a pair of the target council for the financial taxation. That is standing concept, financial taxation, taxation, and repeated of the give it. No, he wants some.
Paper.
Yes.
Lord, if the petitioner is detected in respect of 20 figures of that covered by different parties, and then all of a sudden, Lord, if the plaintiff received a notice from the ADC of that mean that your lordship would find that 33,
Yes.
page 33, and again.
Okay.
I am having a vehicle practice for 26 because now your lordship will see page 34. Lordship, the pattern number has been again, dam number has been given only for 1 lakh 66 lots. And the Jirat sale 9,77,084. What area or out of tag number it could be?
Where is the notice?
This is it.
I have like in my
Apart
PA
from that, lordship, yesterday my learned friend filed an affidavit in which I received after 3 p.m. So I unfiled reply.
everything will
Only-
go on notice lordship. CD notice we have published on paper publication was done 22/3/2023.
Where is that? Want to file a reply?
Yes, Lord.
Let's
What did
Only
I
1
do?
week time.
No, understand. His case is that as per the notice, this is not described properly.
No.
And all. Okay,
And I
fine.
filed objection. The National Highway Act provides that if any object that personal heading to debate.
Let,
So he has
Yes,
filed.
sir.
let him approach the arbitrator lordship. Arbitrator
To
notice
understand,
here.
according to you, since already it is acquired, now any dispute can be determined by the arbitrator under 3G5.
But it is
35.
subsequent.
No.
3G5.
I have no
Anyway,
objection.
you want to have a objection.
No.
Let us have the satisfaction.
No.
You have filed a reply.
Uh,
Is
no.
not it? That
Only
will
one
delay
thing-
the matter for a week, not more than that.
No, only that infrastructure regarding the construction of the road is
understand.
going on.
Now,
We
now,
understand.
Whether
Lordship, it is at a preliminary stage. File filling is going on, Lord.
why we are interested, we are doing the road. You are
No,
not
no, we
interested.
understand, we understand. No issue on that, because he can be compensated. But since you have filed an affidavit yesterday,
Yes, Tatela.
so he seeks an accommodation and will not give you a very long period. We'll give
Not
him,
ye-
I prefer
not
only
yesterday.
1 week.
Hmm?
1 week. I have taken 1 week.
1 week will be a long way. Lordship, how he can
Your
stop
whole
the
thing will start
construction?
from
Lordship?
24.
How he can stop the
file a stay vacating petition.
only status quo order?
File a vacating order. See, if we go by technicalities, there will be many technicalities. We understand, because we do not want the public projects to be stalled, more particularly when a person can be compensated. Here is a case, he has filed a petition, an interim order was passed. Isn't it? You file an affidavit yesterday or day before yesterday. Now he wants us
The day
little
before
agree.
yesterday.
That much only.
Whether he can actually, he's not the owner of the plot. The
That
three-
is a stand in your affidavit,
yes.
isn't
he-
it?
he- Yes.
So do
he-
you propose to say that he need not reply?
No, he can get
Act itself
As-
provide any person interested.
That's
no TC notification he has got. After that TC notification was issued.
hard with the Royal Learned Council. It is
Difficult for us.
stated
not
that
to-
an affidavit in opposition has been filed on 28th of, that is yesterday, today is 21st. Huh? Yes, it is filed on 20th.
Yesterday.
Yesterday. Is the file an affidavit
Oppor-
in opposition by the National Highway NHIDCL
Swami,
on 28th of, yes, it is written in 28th, 20,
20.
28th of March.
Filed yesterday. Lord.
20,
Oh,
yesterday.
they could not find a text. Been copied. Yesterday
Today is
only.
23rd.
I received it
Yesterday. Yesterday.
yesterday.
File is yesterday, and Mr. Roy submit that such copy was served the second half of the day. Accordingly, he could not obtain proper instruction. Therefore, he pressed for an
Okay.
adjournment to go through the
Okay.
same and to respond if to advise. Please this matter on
Urgent lordship. On my side,
20
urgent is there.
57 or 50,
of this one.
because there will be a holiday
Okay. 28.
20.
20.
In trip to
28 interim order factor here.
apply.
Why all these bail methods are here?
My lord, earlier my lord's order was there, but item number, my lord, item number 20, 22 and 23 of same PS case, Hemaji PS case, 149-23. Now we have the information that it has been transferred to CM Vigilance. So, my lord, M. Fukon will appear, my lord, and maybe the case number will be changed, my lord. Now, maybe 3 number. Present status report or along with
Now,
CP?
tell me why this matter is listed here. Any connection, any earlier rejection?
Earlier, yes.
Don't know, my lord. File is
So we also do not know, have an instruction. Now,
anyway, my lord, it's listed in other court also. My lord, status report is required along with the CD.
this bench is taking, as per roster, this bench is taking bench 4 and 5 matter. However, it's not known why this bail applications are listed. In as much as this court has not taken this bail application. Be that as may, as it may, learned additional public prosecutor submits that this case has been transferred to CM
Vigilance.
CM Vigilance Police Station, or what you say? CM Vigilance Police Station. Vigilance Police Station.
Yes. Yes.
Vigilance Police Station, and therefore Mr. M. Fukan, learned public prosecutor, can appear in this case. Accordingly, it's submitted that matter. Prayers stand allowed. Please this matter There is interim. He's an interim.
10th of
10th of April 20. Before Bihu is better, Mr. Chair. Many things can happen before. 9th of
9th of April.
April 2024. Interim order passed.
22, 23 same order.
Anytime paper has been taken, no report has come.
Sometimes these are good things. We cannot adjourn nowadays
And-
bail beyond certain period.
60% all bill has been taken.
It will also be made.
15 has been taken.
It will also be made. That gives you a puja Bihu benefit. Yes. We always think for you. Yes.
21 मतलब 30 submitted.
30 submitted.
मतलब submitted. case number 35/24. That is 29 to 24.
No interim order.
No interest.
For
मतलब
like
interim
that,
is there, but city we have not received.
Huh?
We have not received the city मतलब interim. No, 24 no, change picture.
Okay. Case there. Interim order. When?
Nine.
So don't. I'll have to take this matter.
Yeah, मतलब
Why
पहले
this is? I think earlier rejected. What? Okay, ninth. We do not know what is.
While it's a we don't know.
Maybe there may be due to
Other
the
cases
vacations
also
are
don't-
there. That's why.
Oblige.
Yes, Mahmood. What is this?
My lord, the petitioner has obtained stay order of purchasing on an
Where is the interim order?
other party was here.
What is the stay? What is the issue?
A stay order was passed that what you may kindly see. Page 54.
Where is the impugn order in the writ petition?
There is no such impugn order.
But it says that order dated 25/5/2023 passed by the Register Secretary Revenue and DM is without jurisdiction. That's why
But
interim.
I am submitting a background of the cases like this.
We want to see what is the order 25/5/20.
25 to that is page 32.
There's 32 of give the writ petition. Page 30.
32 and except 4.
Hmm.
तो बात
How can this order be passed?
But I will.
Can
Yeah,
a
but-
settlement officer decide that this is a fraudulent certificate, this is what, this is not? This is a such matter of civil code.
Civil court, but thing is this, they obtained petition order without our knowledge in the land. And we came to know that petition order has been granted in favor of the district. We filed a petition before the ASO to satisfy the petition order. Now ASO took up the matter for this. When ASO issued notice to the present petitioner that on what basis you have got your name mutated in the land, they did not face the ASO. Very cunningly, they were directed to ASO. And the ASO, Assistant Settlement Officer, took up the matter for disposal, whether right petition order has been granted or not. Then they did not face the ASO. They directly filed a petition for the ASO, Dhubri. And he stayed the order of the ASO. But showed the report, ASO, Settlement Officer showed the report from ASO. Settlement Officer brought the report. It was found that by dint of a forced selling, they got the petition order. Then he sent the report to the ASO. Then ASO passed an order in their favor in saying that the parties are not yet properly represented whose land has home. Now my prayer is this: why they did not test ASO?
Mr. Mahmood, you
ASO
are now aware that there is a for sale deed. Period of limitation is 3 years from date of your knowledge. Your whole case will go if you litigate here.
and the state question onward of my IA. First part is Shaharam Talukdar, that means clear. Second part is Firozdar Jamal Talukdar, that means read petition. Statement to document in IO. IA.
Okay.
Then you are
You want that this dispute should be decided pursuant to this notice. That a proceeding initiated by you.
by ASO. We filed a
By ASO.
we filed petition that what the petition order fraudulently by dint of a forced selling. Then ASO took the matter. Issued notice to them. Then, my lord, they did not face the ASO.
No, we understand. Now your case is when it should be taken up by the ASO itself.
Yes.
Okay. So what is your case?
None. Now, my case is this. This is the donated land. When we were minor, then we were donated by one.
What
Abdul
is the
Rahman.
basis of mutation? And when the dispute as regards a fraudulent deed, right, acquisition of right by virtue of a fraudulent deed
Yes.
is raised, your whole case is that this mutation was granted on the basis of a forced deed.
Yes, in favor of the repeat.
Now, suppose mutation is cancelled, what can it be decided? Because say a sale deed law is well settled. When a registered sale deed is there, presumption will be on the registered. You will have to seek for cancellation. And cancellation,
My lord, they are not claiming that is our deed. They say we do not know. They have not clarified their position. But thing is this, Lordship can listen of S25. I am satisfied, Lordship, how the things are going on. Now, the land has to be sold, permission has been obtained, and I am in need of money. They filed this case on the basis of some false documents. I will submit one by one and listen of S25.
Okay.
Yes,
so we are proceeding for deciding the writ petition. Yeah.
Yes.
Yes, you are good.
no problem.
We are going for to decide the writ petition. Yes, madam.
Our it of property. It property. So accordingly, all of them were their names were clear. by S. When they prayed for cancellation of our name, it's the same S. S of cancellation. So we instead of waiting for the S, but then S cannot cancel the name because entered earlier by S. So we prefer the settlement to say the case pending before the settlement of the order in our paper. That was challenged by the private secretary order without. So we have read before this whether if there is a sort of dispute in regard to the position or
Where is the
title,
impugn order?
page 32. First party at the press correspondent. If Saha Alam Talukdar, Saha Jamal Talukdar, one of them
What is the ground of challenge?
their order was first in the detailed report file number 20 submitted by the Kobribari Revenue Circle. This has the reference to the letter number. Peruse the report of the senior sub-registrar Dukti number 2015, stated clarifying that the registered deed number 20 is available, whereas the deed number 1326, same deed number 27/3/2004, which was shown to be executed between Saha Alam Talukdar and Saha Jamal Talukdar, son of Said Abdul Rahman, is not available
Who
in
is
the
in possession of that?
here in Pad- We, Lordship, private respondent is also one of them in their respective share. But Lordship, after cancellation of our petition, have to say
Where is the cancellation of?
this is the it is of the further I am
Cancellation by whom?
by the secretary, Lordship.
Under what authority?
Mutation appeal they have preferred before secretary
Yes, BTC.
land revenue and
Where is the
DMT, but
application? Checking.
that we could not obtain, Lordship. Only this order we have found. There was no
They
notice
approached
of-
the BTC
Yes,
secretary.
Lordship.
Under what authority
No,
BTC secretary?
it actually, it is a accident jurisdiction, I understand. But thing is this.
No, no.
it
If
should-
BTC has exceeded jurisdiction, where should be your grievance should be decided?
I
Tell us.
consider
First tell us.
this matter, they have come not with clean hand. I will prove that BTC has.
Mr.
passed the
Mahmood,
order.
you are in a rich jurisdiction.
Yeah.
Do you now treat this court to be second appellate court over the BTC authority?
And they already have
Normally,
filed one title.
Board of Revenue is the
If
best.
Board of Revenue, go to Board of Revenue, you are setting aside this order.
Board of Revenue.
Or you withdraw it. We say
Lordship,
that we will not,
I am the repeat.
you are the representative.
Yes,
We are setting aside it.
Lordship. Civil dispute is there, Lordship.
Civil dispute, we do not know, Board of Revenue will decide.
Yes, that is the right for up. I understand.
If right forum, then why are you arguing all these
No, I am
registered?
arguing because find out they have, they are contacted. without me.
If BTC is not the right forum, can a writ court be the right forum?
They have come, we have not.
They
So
also-
therefore,
they also have-
our limited jurisdiction is, we will see whether BTC has jurisdiction or exceeded its jurisdiction. Or did not have any jurisdiction. If
They-
it is not having any
They
jurisdiction,
should have go to Board of
Board
Revenue.
of Revenue, board will
Now,
give
They
the
have got
parties.
the interim order restricting the order, but I will prove. Kindly give me some time. I understand that as per Assam Land and Revenue Regulation, the matter should go to the Board of Revenue. But thing is this,
Now whether,
They have
what
got
is
the
what
interim
is your
order.
stand? Any authority? Some land and revenue regulation is mandated. Then you come prepared. Mr. Mahmood. Writ petition is liable to be dismissed.
Then I have to
That I want, but
Writ petition is liable to be dismissed.
yes,
lordship,
Power is vested upon the,
lordship, that they have to file it.
power is vested.
no,
This is a notification.
that I want to say to your lordship.
What you want to satisfy? You have already satisfied me that the Board of Revenue, they ought to have gone to Board of Revenue.
If they are agreed as per their own thing. But thing is this, question is not that. Question is that, my lord, I am not in a position to sell my land. I have to go for treatment. Due to interim order, I have been deprived from treatment.
No. Question is this. The power of Assam land, power of the board as vested under Assam Land and Revenue Regulation 1886 by notification issued by the Bodoland Territorial Council is now vested upon the secretary.
I have-
So you have no idea. So therefore, this authority is having the power.
Lordship, in that case, lordship, the authority
They are, why,
ought to have
So interim order
issue
should be
notice,
vacated, my
lordship.
lord.
Ought to have issue notice, lordship, without
Hello?
issuing any notice
No,
to us.
It has come your lordship notice now. Now they have got the interim
that
order.
is the fundamental issue.
Yes.
That should have been your case. Your case is that, yes,
Interim order should be vacated.
vacated. Why? Because Mr. Mahmood wants interim order should be vacated.
No, my lord.
Huh.
That is not.
Whole issue in the,
So,
listen to me,
tell it
Mr.
back.
Mahmood, listen to me.
Tell it back.
You are a seasoned counsel. Argue on substantial questions of law. Don't go here and there. Whole writ petition is structured in a way. See, there are two planks. One is that this authority is having no jurisdiction to entertain a decision, appeal or a decision, challenge to a decision made by a settlement. Okay? On that, to context, this court only on that ground has passed an interim. Okay? You say, yes, that is correct. There is no, there is, the jurisdiction is upon Board of Revenue.
Right.
You are incorrect. So your first argument goes against it. Because the Learned Counsel for the BTC notified, told us the notification which says the BTC authority is having the jurisdiction.
I have no idea about it.
So that should be your first argument. Therefore, I have asked you not to argue further. Now, their next question is no notice has been issued. Tell us whether notice has been issued.
My lord, regarding
BTC.
that, the order is silent. Actually, the order.
No, you are the petitioner. You know, you went to prepare an appeal
I the petition.
and order is passed
No,
without.
Petition authority call for all the record. And even in my absence, I have only filed petition. Then petition.
I am asking a specific question. Whether notice to the respondent were issued.
I have no idea.
So, if you have no idea, why should we vacate this order? Yes, BTC. These are simple issues where we have wasted time of half an hour. Yes. Hard. But Mr. Mahmood, these are not the cases to be determined either with your ASU or before the secretary.
That is also my plan. That is also my plan.
What prayer? You have initiated all this. You ought to have immediately filed a civil suit. Now we'll have to advise you to.
No, that is not because they are now silent about the fact.
Heard Mr. Mahmood, MS R. Chaudhary, learned in the writ petition, Learned Counsel for the petition. The present writ petition is filed assailing an order dated 25/5/2023 passed by the Secretary, Revenue and Disaster Management Department, BTC, Kokrajhar. Full stop. Inter alia, contending that impugned order has been passed without jurisdiction. The Learned Standing Counsel for the BTC submits that in terms of Memorandum of Understanding, Memorandum of Settlement 2003 between the government of 2003 and the Office Memorandum dated 16/10/2004, the subject land and rent revenue has been transferred to the BTC in as much as by a notification dated 30th of December 2016, the power of the Board of Revenue under Assam Land and Revenue Regulation 1886 has been vested on the Director of Land Record Survey and Inspector General of Registration BTC. And the appellate authority in this context shall be the Departmental Secretary BTC. Therefore, the Learned Standing Council BTC submits that the authority, that is the Secretary, has jurisdiction to pass this order. However, MS Choudhury further contends that even if the jurisdiction is there, the Secretary has passed the order without issuing any notice to the writ petitioners, affecting their valuable civil rights, valuable rights. Full stop. The Learned Standing Council for the BTC shall obtain instruction or file affidavit whether notices were issued by the Secretary to the petitioners herein before passing the order dated 25/5, passing the order dated 25/5/2023, challenged in the present.
There, the petitioner got one dead person because
No, he was not.
That-
there.
That if notice is given, that can be raised before the
No, that is the wrong information. I have annexed the petition.
obliged. When did it
interim order passed earlier shall continue. Yes, when
Already it's got it.
give a date.
Have to do payment.
First week of-
obliged?
Yes, Mr.
Lord, we will
Talukdar.
recollect, my lord, this
Ah,
is
yes, yes.
Western Bank. In the last,
Any development, Mr.
Ah.
Pujari?
in fact, what has happened before my
Now-
learned friend starts?
Yes, now my lord, the entire ball is in the airport.
Yes, you said to me. My lord, anyway, my lord, in fact, what has happened, your lordship directed to, in fact, take a decision at the highest level. Now, by the time the decision could be taken, my lord, the process, it is processed, my lord. It
But
needs-
now by this time, it cannot be taken. It should be after May,
Correct.
at
Lordship
any rate.
will take it. It is there. Lordship will keep it part of the record.
My lord,
My lord, because what I'm.
But how far we will keep it as a part heard?
you may kindly keep it part.
Part, my lord.
We
I
don't
also
require-
request your lordship, because my lord, this will be a, my lord, petition either to revive or to liquidate. And my lord, the reason has given, will have some impact, my lord, on the voters. So on the ground of propriety, my lord, the government, my lord, has decided to abstain. June 4, my lord, I think is the last date when it will be listed.
But if it goes to June, it cannot be a part heard.
No, lordship will do one thing. I'm also accepting. Lordship will, before expiry of 1 month, lordship will fix it, my lord. I'll again take time. No, lordship has taken up. Why I'm saying so, my lord? Lordship has taken up the matter, and my lord, it has got a, my lord, in fact, pace. Now it is moving, man. But otherwise, I leave it to your lordship, man. It's up to your lordship, my lord. But I'm making a request.
See, we want to see certain,
Correct.
there are many orders.
Order.
Our anxiety is that because of this critical situation, our orders, even Supreme Court's order, are not being implemented.
That, my lord, that is it.
We want a solution. We want you to give some time to have a solution.
Yes.
So therefore, that's why we kept it as a part heard so that we can monitor
Correct.
what is going on. They have, I think now,
Yes, now it's moving, man. What? So logical conclusion. I cannot say, my lord, what will eventually the result. But it has taken.
let us wait for some more time. Otherwise, we pass an order, we put them in jail 6 months. Or we may ask, sell it property to them. Nothing more. Let us be a practical for something.
All the report. Bank not it is sort of. Still are even not allowed to enter.
that order, but that the bank. Who will enter? Employees now. Now, safely enough, suddenly, madam, because from 2050 or they did not care to pay the
That's good for you. That's good for you. At least that you have not gone for office by virtue of court's order. Otherwise, they will come and say, no, these people are not attending offices. Now you can say, we want it, but we cannot. We want that order to be vacated.
They will remember us when the election comes. So they will remember us with election. Now that has already happened.
So you do that. You do that. Otherwise, they will say that these people are not attending. We have seen in many cases. They are not attending. They are not entitled for salary. Now, at least you can say that by virtue of court's order, isn't it? If you want to vacate that, will vacate it. Be practical sometimes.
Yes.
Do for election duty. At least you'll do something.
Continuity in service.
Continuity in service. You have an advantage of that order.
Don't know why that.
No recovery that good payments and
You'll get together to get it.
After hearing sometime, Mr. HK Talukar and Mr. Porpujari submit that they may be granted further time to have concrete and updated instruction within a period of a month.
Right.
Is this matter on
3 weeks before expiry of 4 years. अरे पिलो पिलो उन्नीस तारीख को Thank you. Thank you. Obliged.
Thing is on record, I got that when it's taken back, the face is here.
No, we have in fact recorded. We have recorded. We cannot force the government to do something because they will have their own analysis of financial viability. We'll have to balance. We are concerned with them also. Then we'll look into the, okay, you tell it, give them or salary or whatsoever they are entitled. Or maybe some packages, DRS, whatsoever.
And so,
Yes. What is the issue here?
That.
Is there?
Rep.
Okay, rep committed. On.
One 2020.
24 on 20.
20. But it is
The date typed as 24/12/2021 at paragraph
no
3.
2022. 2022 at paragraph 3. Kindly see the last second last.
Paragraph
second.
2020. 24/1/2022 at paragraph 3 and
6.
At paragraph 6 and
Paragraph
para 7
Seven.
ought to have been 24/1/2021.
20.
20.
Two.
20. 2020.
Because paragraph 7 logic with effect from 25/1/2020 is noted.
Okay. 2020. No dispute, no? Or we should call Mr. Ali.
I thought so.
Okay.
And if for a moment, kindly the petition absolution.
Give it.
Para 9.
Okay.
Para 9 is state.
Para 9.
Para 9. Sorry, page 9.
Page 9.
Page 9. That is his state.
Good stop. Peruse the repetition.
Sir.
Stop.
Last.
At para 9.
Page the para 7, page 9.
At para 7, page 9.
It continues to page 9. The last sentence.
In the last sentence,
In terms of order dated 24/1/2020, the general manager went to issue the release order.
in the in as much as the petitioner pleaded at para 7 that the release order was issued on 24/1/2020. Considering the matter in entirety, present application is allowed, and the date reflected in paragraph 3, paragraph 6, and it put this paragraph 3 and 6 and 7. The date that is 24/1/2022 should be read as 24/1/2020. ISS. Item number, but today's item number 44 is which code? Code number 27, item number 34.
44.
Today's
Here it is
34 and that is 44. 20, is it? Where is Mr. Puya? He has gone. Yes, madam, baby. What is it? Item number of that code. You are aware? 2021 of code number 27. Here is a case, there is some rape alleged by some army person. The victim, that is initial entry,
No, 18, when the age is 18. We have taken his entry date as 18.
18.
That's why we have never said he was minor. We have never said. He has produced his certificate after his, after working for 7,
So
8 years.
what was your date of regularization?
19, regulation 85.
83, madam.
What was your
Well,
age?
the Supreme Court judgment is
What was your age
That depends on the 12 years.
at the time of
Entry.
time of regularization?
Regulation, no. Then major.
Then measure.
Then-
Now you are being given benefit from which date?
From the date of regulation.
From the date of regularization.
Then
Suppose we from the date of regulation, when will you retire?
2026. February.
no. From
No,
from
from the
19.
date of entry as a temporary
So if they have
appointment.
counted 33 years from date of initial entry,
Yes,
when he was 12 years.
Yes.
According to him.
Him.
According to him.
us, it
According
is
to us, it was 18.
18.
So from 18, they have counted 33 years. Isn't it?
42 years.
42 years.
But all
See, your principle is a reasonable principle. Will not say not absolute. But the law is there is a divergent view. According to
that's
you,
that's the logic.
according to you, if a person enters into a service at the age of 18, which is a legally permissible and
Not-
date of
And
entry,
the rate of
a-
retirement
a
being 60,
person cannot serve an institution beyond
42 years.
42 years. So therefore, we have treated your service to be 40 years from date of your entry and accordingly ask you to go on superannuation. This is your case. His case is that
my case is that my actually date of birth is so that I ought to have retired 20 February 2026.
so whatsoever
But there is no rule. There is no rule of 42
so
years.
therefore there is no period. It may be 60 years of service.
That's what.
This is your
When
case.
everybody is working for 42 years or less, and he wants to work for 48 or 49, that cannot, then
whole view is that if there is a 60 years, he must be retired. But there is no rule that how much length of the service, there is no rule framed by the any state. This is a general view. That is the view.
So according to you, the principle is also not declared by the employer or per se or to say Union of India saying that either it is 60 years or 33 years of service. This is not the policy. The policy is that attaining of age of 60. So have you attained the age of 60, you cannot look into the situation back first, and secondly, my entry into as a canteen boy. It's not an officer.
Yes.
So you cannot unmindful of a situation of Indian situation where even after bar, child labors are being used. We are in your favor, but whatever decision we take will have a greater ramification everywhere. So we'll have to pass a judgment on the basis of the principle laid out. Therefore, we asked for those judgments, and now we found that the judgments are also in type 2 views. So we'll have to take the appropriate view as per our decision, and that is to be tested by FCI updates.
The Rastogi view is that there is a contract. Appointment is a contract. As per contract act, minor cannot be appointed as a service holder. That's why it is illegal. So official view, official order is prevailed. When he was entry as a regular service, that order must
Okay,
be considered.
are at some length.
I contended, I have not
However,
contended that
the
benefit.
hearing remain inconclusive. Mr. Bora has also furnished one judgment rendered by the Honorable Apex Court, the case of Gopal Prasad versus Bihar School Examination Board and others reported in 2028. This matter be set for further hearing
After the
after
They have
19.
paid. Another judgment I have referred, I have
Already,
Purisa.
Okay.
Exactly my case. He was already continued service.
we will go into if it is inspires us or persuades us. Let us not binding, but if it can persuade.
Yes.
Let us see.
But if I have to clear for I but it
That is gone.
has for good
So we have passed this order signed also. Tell him that interim order is not extended. Tell him. No, we cannot. We pass that bail order we have signed also. It is uploaded. Tell him that it cannot be. Prayer is rejected.
Matter is to my lord Santo TRS. The fundamental question was my lord Rule 56.
My
See
lord,
my
my lord, with what you apologize, my lord, I was supposed to go through the judgment, my lord. I was last 2 days, my lord, was very
Okay,
busy, my lord.
okay, no issue. We are also in the midst of tax, land acquisition. Do not want to go to the, what you call it, Mr. BRS, after view.
he is also without any salary in
And we just wait till view. Their issue is the period.
No, my lord,
That is his argument.
no, my lord.
Was withdrawn. So therefore, his argument was that even if I do
assuming
not, if assuming that I did not withdraw, what is the principle of what should be the period? According to him, this is the cutoff date. Whether I withdraw or do not withdraw, you do not assume jurisdiction to take a call on that.
Unless, in that,
Okay, so,
About the approval. Approval.
okay, that is the basic, very limited,
It won't
very-
take much time, my lord.
it
These are
is
the-
very limited issue.
Yes.
no
Facts are not in dispute except one,
Super legal issue.
only issue is, only a dispute is that he said not withdrawn, you say withdrawn. That is a disputed fact. His second line of argument is, even if it is not done, you do not have a jurisdiction to act in the manner till this date. This is
Yes.
okay.
Exactly. And also the approval, my lord, also to see that approval part.
And there are some
Yes, yes.
Mr. Thor will have, okay.
And date, any date, my lord.
Okay, your facts more or less is clear. You say that these are the only factual for you. And Mr. Thor was supposed to address or something.
Fine.
Mr. Thor, learned counsel for the respondent who was supposed to advance his argument today. However, he submits that due to some difficulty yesterday, he could not properly prepare this case according to 6 and is this matter on
25th.
23rd.
today is
Today is the,
21st. It
20th.
cannot go beyond 21st.
my lord, make it on 9th, my lord. It's Tuesday, 9th April.
That is
Not possible.
before.
Okay, okay. Yes.
My lord, suppose
No.
till 21st, 19th,
19th, make it the time.
18. Reopen. We will also look into this.
Right.
On last occasion, I have gone through certain things because but I did not put any note.
We can.
That homework I did, but now I forgot. I will have somewhere
Yeah.
in my computer.
Here, my lord, my technology will help, my lord. If you can retrieve the video in YouTube,
Ah.
it is there. My
No,
lord,
I did some homework and some notes. I think it will be in my
Like this,
hand.
okay.
So I'll have to also. I could not find it.
Fine.
Or Mr. Nath, should we release it from part or change it?
Should take
Yes,
much time.
yes. No, you have anxiety of not get. Yes, Nath. What to do? Only dispute remains is what?
45,175.
More or less, it is determined that you don't have. You also
No,
say that
there is an interim order, and the state went on the appeal against the interim order. There also, our court has dismissed the appeal and out to release the.
that has been released.
That-
So more or less, nothing is here except the legal issue.
Legal.
Only is the question they are raising is that this is my amount 100 bags of Tuancho, but I have been released only 80 bags. Now, what kind of order? Suppose assuming for a moment that this is established that yes, it was 100, only 80 is given. What kind of order we can pass? That's why we want you. Isn't it? This is the issue. Where is that 100 bag and 80 bag is admitted position? Because that should be an admitted position. Is not it? Otherwise, we cannot pass an order.
That is
Where is
because
that?
it is in front of circle officer in other of the various
Do you
parties.
want to know the siege? How many bags were seized?
But if the teaser list is at annexure I, there are two teaser lists. One is at annexure I, page 50.
Page
58.
58. Mr. Nath, go through.
The first, the point number 1,
58.
the lordship, the point number 1, total 705.
Numbers of jute bags containing dried supari found in the premises of the group.
This is what has been
Okay,
Then, Lordship, there is one more teaser list, which is at page 54.
50,
Oh.
54
Yes, yes.
previous. Can you prepare a list, in the each of the cases, what are the amount and where is the page number of the seizure list?
But
If-
this is the total. Because,
No, there are too many cases. Na?
but in all the three cases, it's the common, Lordship,
Okay,
common teaser list in respect, because they are sister cousins.
Okay.
And the goods were in the same.
okay, goods were in different name, but seizure is one from one gooder.
From one got out, and they are sister cousins. They are three cousins, all are sister.
Okay. So 54, where is that?
But to page 54, today I have seized a total number of 225 bags.
Where, page
54.
54. Today I have said total number of 225
bags
bags
containing
containing dried supari along with following documents. Okay,
this is 225, and that 705. This is the total.
okay. Now, where is your return
This-
pursuant to this court order?
Not if this the total number 7065 plus 225 makes the total to 749. So thereafter, not if there was a
7490 means
bags of
total is
7290,
225 and
7065.
7065 plus 225. Is that it?
Yes.
So total is 7225.
Page 57.
75 bags.
7230.
Yes.
Huh?
706.
7065.
22.
And
70.
65 and 225. Total number of 7290 bags.
7290. Okay.
Out of which they have released 5540 bags.
Where is that? Where is the release?
They have their website also stated. There is a
No, have they
in
filed
their-
any
in their- in
affidavit?
their affidavit also they have stated.
Where is that? Who has that affidavit instead of paper?
You know, the correct course of it.
The affidavit, I just pointed out of context. Annexure A ultimately this shows that the jurisdiction they themselves
Which one?
annexure A
Based
of the affidavit they have filed on
by
15.
Papuri Setia.
Yes, Your Honor. 15/11/2017 they have filed two affidavits. At page 10, annexure A.
In exercise the power.
This is the power of BIU, total power. In exercise of power conferred by clause 8 of section 2 of CRPC, the state government do hereby declare that office of column in column number 1 of schedule number 1 below shall be the police station, and that it shall include within its limit the area specified in column 2 of the state schedule for the purpose of offences mentioned in schedule.
Hmm.
The notification comes in force. But if since it's a special week, this is BIEO jurisdiction for state of the schedule 2 is the offences only these officers they are allowed to investigate. They themselves have given this, and this does not contain the offense for they have done the murder. So this is out of their own document. They have vision of
Offenses relating to evasion of taxes and
by what
taxes under the
for it.
excise
black marketing, copyright, sale of narcotic drugs, criminal breach of trust, circulation of counterfeit currencies, and white collar crime, or any other offences which will be specified by strict law. This is the only area of Lordship where they
Now,
can.
according to them, what was the offense?
But if earlier they had, when the certain seizure was made, they did it on evasion of tax.
Hmm.
Then Lordship, when we pointed out to the court that at this moment, evasion of tax, the central government has barred all the any person suggested, then they came up with a suit that is stolen goods. Then Lordship, when we showed to them that for stolen goods, somebody must have done a complaint before the. Then you can say that it's a stolen. They have section 397. That also cannot be there. Then and there is a specific finding in the interim order that they had admitted before the court that the goods were neither stolen nor kept under any suspicion. Thereafter, the thing that it is most probably stolen, smuggled goods. We are not sure exactly what offense they have committed. The statement they have made for the division method. But till now we are not sure, but they must have done anything. We'll find out and we will something about. So finally, they came out that maybe it is a smuggled good. At best, smuggled good. Lot if they have not given, they cannot.
Even
Smuggled
smuggled good will be the excise.
And finally, the customs will be the customs court. And finally, Lordship, they have after this case was done, they have filed an additional affidavit. They have shown that they have taken a Lordship from the Lordship, some private agency at Bangalore. They have taken my temple of Supari from some private agency at Bangalore. They have done some investigation. They found out that maybe that is also suspicious. That maybe it may be of a foreign nature, and that is also private. There are
So, assuming that it is a foreign nature, then who will act?
only customs
Only
could
custom
have acted. Could
Huh?
have acted. Now
would have acted custom.
7 years. It's 7 years back. They have
Now,
taken.
what is your challenge in this writ petition?
My challenge was certain season. I was challenging the certain season that a certain season, and therefore that should be declared as unauthorized and illegal. That was my main.
Now,
sort of-
according to them, they have made this certain seizure under what authority of law?
That's what they have changed the statute.
Now, where have they have changed it?
Lordship, earlier Lordship, the first I will show Lordship, Annexure 1, Annexure I, page 58. While
Yes.
doing certain seizure, they have declared.
Page 58.
Page
Let us
58.
see their stand so far relating to, we can understand your page 50.
58, Lordship, the type copy is at page 57. Type copy is at page. Lordship, they have given me the reason of certain. Certain seal of Kumar Enterprise and Mark Kearney godown situated three firms to godown situated in main road, so and so by a joint team of DIO comprising of Lordship Superintendent of Taxes, this is the tax officer, Manjeet Bora, and Sri Digambar Jain, Inspector of Tax. So they have mainly done the search and seizure under supervision of
Suspecting to be evading tax
Evading
and
tax.
other. And
so they
okay.
evading tax. So this is the reason they give for my certain. When I did the case, Lordship, in the interim order, Lordship, I will Lordship,
Okay, this is their stand. It is reflected from the certain seizure that it is under for evading tax.
evade.
Okay, then
Lordship, thereafter, when this matter was moved, and we said that they don't have any power under GST as yet, because GST was at a nascent state.
Hmm.
1/1/2017, the GST had come, so the central government wanted that every dealer should be prepared for it. So, Lordship, the certain seizure was done within 27 days, 27th of July. 1st July, the GST had come. At that point, the central government has given a specific direction that not even a single dealer should be rated so far as taxes is concerned. So that is what
the conditional period.
that was a nation bill. So that time, and it was happening all over India. That is why the government had to issue press circular, press notice. So those I have annexed that there can be no certain. So when this was pointed out, Lordship, they changed their stand before this honorable court, and Lordship may kindly see that the interim order which was passed by this honorable court. 16/8/2007. 16/8/2017, the interim order passed by the Supreme Court
16.
2007. Copy of 16/8/2007.
Hmm.
If the it starts from paragraph 3 first. Earlier also an order was given.
That
It has been reflected over here that what is the grievance of the leader. Lordship, the main Lordship starts from paragraph 2. Ms. K. Fukan, learned government advocate, has received instruction from the BIO and submit a police rated go down under section 102. She submits that the thief suspected that the directorate in the ground were of Burmese origin and were smuggled to Mizoram and was stored in Guwahati for onward transportation to other parts of Mr. D. Sekia, learned additional advocate general, submits that collection of tax and prosecution of defaulters is the responsibility of finance and taxation department, and arrears are liable to be taxed under AGS. The learned assistant solicitor general, so and so, on the other hand, submits that it is if it is a case of customs duty, the concerned police team should have informed customs authorities instead of acting on their. So, fourth paragraph, that is the main paragraph. This is the finding of the court at that relevant point of time. The stored arachnids were neither stolen nor kept in suspicious circumstances. Stolen lordship was gone. At best, tax is payable for dealing in arachnids, but that would be in the domain of finance and taxation department. The submission made by the additional advocate general and assistant solicitor general reflect that BIO team may have acted beyond their jurisdiction. Therefore, the learned government advocate paid for and is granted free tax. And this was lordship. In the interim, it was granted to facilitate the petitioner to carry on their legitimate business and taking note of the fact that rate of tax 2.5% on arachnids and under CGST and 2.5% to central government, subject to petitioner furnishing bank guarantee of 30 lakhs. Towards the estimated tax, the Commissioner of Taxes should release the custody of the petitioner the 7290 bags, the total bags of arachnids after due verification should be released in presence of the tax department official. However, the transportation and business of arachnids is subject to direction of tax by the authorities at the bank. Order to be deposited and is only an order transfer. This is the lordship interim order was passed and then the lordship.
Now, in the meantime, you have given the bank guarantee. Matter was released, but there is some shortage.
Shortage.
Now, where have you objected such shortage?
Last thing I will point out is the division bench order.
Okay.
They had appealed for the to the last paragraph.
Yes. Okay, now what happened thereafter?
There's a specific that it can be
admitted.
admitted that authorities are still not sure which offense.
Okay.
They were trying to find out, but it's not the way in which search is made. They have to be
Okay.
sure on the day search is made what exactly is the offense. They did the search and search, then they started finding out what offense I might have. So thereafter, lordship, the goods were released by the authorities. Lordship, the authorities has released the goods of they have released only 5540. Lordship.
Where do you get that? Because you have not filed any contempt or anything to say that this was a direction, but they have done it this much only. That is not, that is what we want on record, either from their admission or anything, any affidavit file, anything on oath that you have said that this is what has been done.
But-
Or anything, any documentation where it is said that you have received.
Receipt of 5540.
Where is that? But is it not necessary to
bring that on.
bring that on record
It can be
and give them a chance to reply, they know this is not the correct position.
Lordship, Lordship, they have also filed an FIR in that regard. I will bring that to record, in which they have admitted that yes, we have this 5540. I have also filed my FIR 5540 and the circle officer report also there. Lordship,
That is very vital because more or less so far relating to the, what is the issue here? Issue is Sergeant Session. So apparently subject to what Mr. Nath says and Mr. Chaudhary says, we are more or less prima facie of the view that might be you did not have the sergeant. We'll set aside the sergeant seizure. So moment we set aside sergeant seizure, there may be a new cause of action for you to claim. So I think let that be in the for the new cause of action
Lordship,
because that is not your prayer. That is a arose out of the interim order.
because they have not.
Huh,
filed the
that we
interim order.
understand, but at the same time, you also not acted promptly. You have not filed any contempt, saying that see they have not returned it.
I pointed out for the court and they for filed an FIR.
Oh, that
Lordship, I can advise Lordship, bring that on record by tomorrow. And Lordship, I can only advise also pray that since they are not released after the interim order, I may be given liberty to file for compensation for a
that
liberty will
is
be given
because I
for
think
months
they
and
say
five
that this has been stolen. We cannot give them to the again. It will be a determination what is the cost and all. So we'll give you that liberty to have appropriate action whatsoever for seeking compensation or any remedy available for it.
before
will not
appropriate for
appropriate. We will not say anything that this court or any court will simply say for compensation or any other relief that is permissible under law in view of this direction passed in this court and in view of their allegation that only this much is that much.
That.
Yes, Mr. Nath.
Lordship may examine the matter. The what authority otherwise affidavit they have
Ah.
already under section 102 and 156 they have I'll accept the honorable court rejected order. Already the customer has the authority.
No, what is your stand in the affidavit?
No, in
Under what authority you have done it?
in the affidavit, what I have that they have said that no case has been registered. It is in fact we have said that a case has been registered and the sample has been captured. And 102 CRPC, 156, section 156 CRPC, they have stated that police
What is the offense?
that is
There is no offense.
Hello.
So we'll close it.
let
Why should we keep this matter pending till 2016?
since okay,
Is not it?
a
In fact, on the interim, by the interim order, entire relief they have got. Only we'll have to just close it, just recording the earlier interim order part and quote your affidavit. What is your stand?
yes,
And we'll say that from your affidavit also nothing is discernible. What offense is that in that view of the matter? The sergeant says that it's set aside. Sergeant says that it's set aside. You will at liberty. What if there is some offense?
so the case has been registered in the
Case has been registered under what provision?
the
And when?
annexure 1 or page 4. They have
Annexure 1 of your affidavit.
so the second affidavit filed by Papuri here.
Second affidavit filed.
Additional affidavit. Respondent
Okay.
number. Here I find a mention of PIO PS case number 19 of 2017.
their own.
Yes, yes.
That is also under check.
Correct.
State.
No, here
That
in-
is challenge and
in this
Before this honorable court of the criminal petition he had filed under section 4 stating that they have no authority to file a case in their own and further this was a custom case. Lordship, that is already under state and
no. This sample has been sent in a case BIO police station case in 2017.
Yeah.
What is the allegation in this case?
that is the
I'm just stating. File copy I don't have, but they have already.
No, any statement made that we have registered against this section?
Registered a case.
No, under what provision?
But that is not.
Why they are shying away?
That is not.
Because they have registered this case might be for the stealing of those Arakanat. Is not it?
On suspicion, that is their stand. But that I'm sorry. But if Lordship today close this petition, interfering with this period, the case registered by them, because that is not on the challenge.
Let it be because their whole challenge is the seizure. You have not been able to show. See, Mr. Nath, kindly come to paragraph 3. Read it for everybody's information. Read it.
That the deponent begs to state that on 27/7/2017, following receipt of information from reliable source, the Bureau of Investigation Economic Offences Assam conducted search and seizure in the godown of the petitioner located at Amingaon and seized betel nuts, areca nuts from the state godown, which are suspected to be stolen smuggled. In this regard, BIO, Bureau of Investigation Economic Offences Assam has registered a criminal case being BIO PS case number 19. Stolen or
Stolen or smuggled, that cannot be both. Moment it is smuggled, you don't have any jurisdiction. And if it's stolen, what is your notification says?
They cannot
Notification, let us see your power notified. BIO, where is that affidavit? Your affidavit.
Anecdote, please say. The
send,
first step.
25.
Offenses relating to evasion of taxes by court.
That is offense of this is not your case of evasion of tax. It is your case. Moment it is smuggled, it's a custom duty. Moment it is smuggled means it is without authority brought from an other state, from outside the country of foreign origin. There are certain lists under the Custom Act schedule is there, which can be taken inside without or not without paying custom or with payment of custom.
That normally comes at a subsequent stage because at first it comes to
No,
it comes to
that
police.
fine,
and
that come to police, but police is
It
at
goes to
any rate having power to have search and seizure. Their responsibility to inform immediately to Mr. Kyle. Isn't it?
that is in fact in the order.
Then-
in fact in the order it is.
Then they will do the search and seizure by the custom. That procedure is also different.
That is-
We'll set aside Hart, ML, Gop, Learned, oh no, and Haveli, Learned Counsel for the petitioner, also Hart, Mr. D. Nath, Learned Senior Government Advocate, appearing for the respondent numbers
So that I am appearing for 3, 4, and 5.
3, 4, and 5. Gogoi for 6. Custom and yes. So you will support her case. Your jurisdiction is in and yes. It was their duty to inform you that yes, these are we suspect it. They even cannot say that this is foreign. They said we suspect it to be foreign origin. Please act. That may be sent. Custom act. So you will
Mainland country.
Yes.
It is there. Better to take.
and Mr. Chaudhuri for 1 and first order is of type this order will I correct it later. 9 and this order. Yeah, but 16 and 9. Which is there. From Mr. D. Nath, Learned Senior Government Advocate, submits that relying on the affidavit filed by the respondent number 3, submit that
respondent number 5 as
Respondent 5. Respondent number 5
On-
submits that.
On behalf of three,
No, on we have 3, but we are
Yes.
saying relying on the affidavit by
But-
respondent number
Number-
5. No, who is for respondent number 5?
2, 3, 4, 3, 4, and 5.
You are okay. Respondent number 5 submits that following a receipt of information from a source regarding stocking of huge quantity of stolen / smuggled dried betel nut in a godown located godown in question, the team of BIEO was sent to physically verify the information. And when the owner of the godown could not produce any document, the authority suspected the goods to be stolen / smuggled, and therefore search and seizure was carried out in the presence of. This is your case on affidavit, magistrate. In the aforesaid context, therefore, Mr. Nath submits that there is no illegality in such search and seizure, inasmuch as the BIO is having authority by virtue of a notification dated 11th of September 2003 within bracket Annexure A to conduct such search and seizure. From the stand of the respondent, it is clear that the BIO searched the premises and seized the 7086
7 to
7 to no, but what total was 7290 bags of total 7290 bags of dried supari from the areca nuts from the godown in question, suspecting them to be smuggled / stolen goods. Yet another additional affidavit has also been filed by the respondent number 3, which discloses that sample of the areca nut has also been sent for testing. The such affidavit further reflects that the authority suspected the said areca nut to be stolen and smuggled goods. Smuggled goods. Now the question therefore arises whether the BIEO is having any authority to conduct search and seizure in the given facts of the present case. That is, the search and seizure was conducted on the basis of an suspicion / information that the petitioner are storing within inverted comma stolen / smuggled areca nut. Full stop. Smuggled areca nut. The respondent BIEO is relying on a notification issued by the Governor of Assam dated 11th of September 2003 and 2003, according to which the BIO is empowered to make such kind of search and seizure. Full stop. As the said notification dated 11th of September 2003 is stated to be the source of power of the BIEO to conduct the aforesaid search and seizure, said notification is quoted herein below. Page 83, Annexure A. A bare perusal of the aforesaid notification the following power, it is clear that the said notification and empowered the BIO to do following things. One, that clear that the said notification was issued in exercise of power under subclause what S of the section 2 of the Code of Criminal Procedure 1973. By virtue of the aforesaid notification, it was declared that the office of the IGP, Bureau of Investigation, within bracket economic offense, Assam, Guwahati, shall be a police station, and it shall include within its limit the area, it will include include the whole of Assam for the purpose of investigation so far relating to the offences enumerated in the Schedule 2 of the notification. Further, a bare reading of the Schedule 2 notification, the said police station under the notification dated 11th of September 2003 is not empowered to investigate any offense under section 370, stealing goods, 379, 379 IPC in IPC in as much as the Schedule 2 offenses basically relates to economic offenses such as forgery in connection with evasion of taxes, offenses under Essential Commodities Act, offenses under Forest and WLP Act, offenses under Excise Act, etc. Inasmuch as the such offenses has been empowered to be investigated by the police station of Bureau of Economic Offenses. Both of these Schedule 1 and Schedule 2 reflects that the intention of the notification was to make us to create a special police station having jurisdiction over whole of Assam for investigation of economic offenses relating to different acts. Therefore, a simple offense under section 379 cannot be investigated by the said police station. Now coming to the question of smuggled good, full stop. In terms of section, Gogoi, where is Gogoi? Section dash 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 of the Customs Act and the notification under the investigation and search and seizure is empowered so far relating to the smuggled good or good say power to seize good brought from which are of foreign origin and which and where there is violation of custom acts is upon the custom officials not under BIEO. BIE. There is a judgment division bench, Aizal. Are you having that? No. My lord, Justice Kumar, division bench, I think that because it's basically this happens, this foreign cigarette and Arecanut at Aizal, it has been seized by either Assam Mizoram police or by the Assam Rifle. There is no cust. They will not even inform the custom. So there is a division bench judgment or single bench. I forgot. Anyway, so you will not get this judgment uploaded before me. These are all gap. So in accordingly, this court is of the unhesitant view that the BIEO is not empowered to do the search and seizure in the admitted background as pleaded in the affidavit by the BIEO themselves, and accordingly the impugned search and seizure 27/7/2007 stands aside. At this stage, it is submitted by the learned counsel for the petitioner that though total 7290 bags of Areca nuts were seized, however, pursuant to this court's interim order dated 16/9/2017, 16/8/2017, only how much?
554.
5540 bags has been returned to them and not the remaining amount. It is also stated by the learned counsel for the petitioner that the BIO themselves has lodged an FIR
In their
in their own police station regarding stealing of this Arecanut from their custody, and same is under challenge in before this court in
the criminal
criminal petition number. Give those particulars, whatever I am the criminal petition number 20. Be that as it may, if there is any shortage in handing over in the seized Arecanut bags in terms of this court earlier order, and if that has been the petitioner shall be at liberty to approach any forum available under law for redressal of their grievances. Redressal of their grievances, including seeking compensation.
in the information packet. One respondent number 2. That may be
The bank guarantee furnished by the petitioner in terms of this court's order dated 9/8/2017 for release of the seized Arecanut be released to the petition by the respondent number 2. 110 na? Wait, I got the custom check 110. Case number, criminal case number you provide. But madam, you will get it after on upload.
There is a judgment. It is reported in 2021 TLT 462. There says that investigation. My Lord Justice Koteshwar
Okay, 2021,
2020,
Ah.
1 40.
40.
I also.
Yes.
20.
No indulgence. Indulgence is refused. No interim order is extended because Mr. Chaudhary has not made prayer and will not. Why you forgot? You are a young man. It is bad thing. You have not only forgotten, you will have to shake your ears. Immediately, visa is a vacation. Go and have to get your ears tested. Because you have already extended this interim order.
In my, is that objection, ma'am? It's totally on the ground that some statistics
Where is that Onima? Who is representing Onima? You are. Oh, please.
the objection lawsuit is cited 370.
No, no. Who is Puleswari?
And who raised the objection?
Where is she? She is a party here.
Yes.
Not a pair.
The lawsuit may kindly see paragraph 2 matter. But that in connection with the state court of then CPC petitions and the trial.
Where is the judgment that that it is the referral court, not civil suit? Huh, that judgment that SD Purakas relied on it. Very curious.
False ever made accepted or accepted court that have annexed
Yes.
at H9
That's why we, instead of going there, moment we send it, if we don't decide, then it is to be reference or what, we cannot say. We want therefore an instruction. So that if award is passed, pay him. We'll pass that order. For your interest.
Same day we have been communicated from. I also talked with the that ABC matter. He talked with that he will be back in touch.
Mr. Andy Claret Council submitted. So he had intimated the concerned official for the instruction as directed by the this court under its order dated 13/2024. He may be granted some further time to obtain specific instruction. In prayer is allowed. Please this matter after Bihu. We'll fix a date after Bihu last part 30.
Even the response number 1.
Huh.
Goes to the
None appears for the private.
the commissioner secretary Gopra there is no department which will be represented. It is nothing has been mentioned.
Yes, but
My learned friend, I told her to appear.
don't appear. Anyway,
But she cannot
why
appear.
you are so casual? Yes, next case. Yes, award pass. Huh?
What has been passed, but they are not in possession.
No, forget about it. If award is passed, let them give me that. That instruction will record and they will have their parties will have their own remedies under that.
Yes.
Where? Which order? Impugn order?
17th.
Okay, let us see the act. Ayush Act is not it?
Right
2013. Okay, 2013. Okay, okay, where is that?
Lordship will find it from 21 method, section 21.
Okay.
That is the notice to interested. And thereafter, Lordship will find it page 20.
Just a minute, notice to interested party. The collector shall publish the public notice on his website. The public
Because he has the power to decide whether person are interested or not. Have interest.
Where is that? Just to ask.
Lordship 23 Miller, inquiry and acquisition award right
23.
on the day so fixed or on any other day to which the inquiry has been adjourned, collector shall proceed to inquire into the objection which any
If any.
person, if any, which any person interested has stated pursuant to the notice given under section 21 to the measurement made under section 20 or into the value of land at the date of public notice and to the respective interest of person claiming compensation and rehabilitation and resettlement shall make an award under his hand. Below section 64 comes when award is passed, then only the reference code has used. It's the language of the it's a section 64.
So what according to you, what is the mandate of section 22?
Possible find that my affidavit.
No, let us understand the law. Section 23. According to you, what is the mandate of section 23?
Lordship, this is the inquiry proceeding after notification
Now, and then when award will be passed?
and after inquiry into the land and after ascertaining the interest of person, then it collector shall pass the
Award. Now, where is the award here?
Lordship, that must have information because
So therefore, see, Mr. Mohanto, once again you read section 22. Once again you read section 22. Go
On the-
slow.
on the day so fixed
Hmm.
or on any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objection, if any, which any person interested has stated pursuant to the notice given under section 21, to the measurement made under section 20, and to the value of land at the date of publication of and into the respective interest of the person claiming the compensation, rehabilitation, resettle shall make an award under this hand to area of
Okay, under this. So, this is a procedure for passing an award.
Lord.
So therefore, the order that has been passed, is it an award?
No.
If it is not an award, then that is to be included in the award.
Lordship, because
So there cannot be two stages
Lordship.
that I will decide this, now I will pass an award.
Lordship, only if Lordship peruse the impugn that is only their with regard to their entitlement, because by that order it was stated by the collector that your land has not been acquired, so you are not entitled. Because that is they are
Has not this is the problem, therefore we will set aside that. Reason is that this section 23 says that issue a note after issuance of notice under 21, there may be objection. If any objections are there, if there is no objection, no problem, pass the award. If there are objections, hear the objection and pass that. So there is no scope for hearing the others and declare that you have no right. Thereafter will pass the separate order. This is not the problem. That award should include that you are not having, he is not having.
perhaps that has been
So therefore, that order impugned by any stretch of imagination can be an award.
no,
Well,
no, that is not a
So if that is not an award, that is not an power exercise under section 23. Section 23, it is to be passed an award only.
Lordship, this order is passed on the basis of the application.
Where is this provision and scope? Show us
Because
there.
being a review board is
So,
because
do you want to say that the authority, now let us see the power of reference.
section 64,
Okay, let us come to section 64.
64 will come after passing of award.
Ah.
Lot.
64 will come passing on award.
Yes.
So let us come, page 64.
59.
That provision, section 64.
64.
Let us read together the section 64. Yes.
Reference to authority. Any person interested who has not accepted that award, that means after passing of if company may by written application to the collector require that matter be referred to the collector for determination of the authority as the case may be, whether his objection to the measurement of land, the amount of compensation.
So same relates to section 23.
Lord.
Huh?
Lord.
And
As
who
a
it is payable.
Lord,
Same relates to.
Lord.
So he in a award he will do this.
Lord.
So therefore, until and unless an award is passed,
Lord.
how can he seek an reference? And where is the power of the collector to pass two separate orders, one determining thereafter passing an award?
Because
That award should contain why I have passed this order. And in that award, they will have to, therefore this order is liable to
if
go.
award is passed, that has been that
No,
may
that
have
will
been-
come, later on.
Sir,
We are addressing your argument.
Lord,
That this is not an order, this is not an award, this is an order under section 23.
Lord.
Section 23, except or award, they are no power to pass separate order.
Lordship, because Lordship, I go to the, there are more than 3 inquiries because this
No, we have no problem. We have gone through it.
Lord.
We have no problem having inquiry.
and even
But we want the power.
even if
We want the power.
Yeah. even if Lord, if we rely on the section, then it was the duty of the petitioner to make a application before the collector by stating that since you have done this and matters.
When will he pass? When will he file that application? When there is an award.
Because this application is order impugn is passed on the basis of his
Order impugn is passed without having authority. You
If-
show us section 23 and show us that there can be a separate order without the award. So section 23 empowers a collector to pass an award,
Lord.
not an order that has been passed.
Lordship,
So if you say it is under section 23, it is liable to go.
Lordship, I am to because this order is only with regard to whether their land is acquired or not. There is nothing more than
No. The question is this. A notice is issued.
Lord.
Person interested are called. He says, this is my land. Collector say, no, this is not your land. Collector is not the ultimate authority in the scheme. So collector in the award is to say that you are not person interested. Therefore, award is not passed in your favor.
that is stated in the
But where is the award?
Lordship, that must have
So
information.
therefore, forget about them. I am repeating it. I am repeating it. Forget about them for the time being. Your argument that the collector is having power to pass an order under section 20 and accordingly this order has been passed regarding entitlement. That entitlement is to be incorporated and included in the award under section 23. That has not been done. That is his grievance. Because you cannot make him remedialist.
Yes, certainly, yes, it's the order.
This order cannot be passed
My
without the award.
my understanding, Lord, is for passing this.
Hmm?
This impugn order is passed for finalizing that.
There, where is the scope, provision? Tell us. Tell us. Tell us.
If Lordship kindly what has been produced, I have,
No,
such
we'll
documentation.
see the record award passed or not is a different thing.
Right.
We want to have a satisfaction of your argument. That the collector, because you have argued a point, we'll have to answer it. We'll have to answer it.
Lordship,
You say that our collector is having a power to pass an order first determined and subsequently he will pass an order. Where is that in section 20? Section 23 says that in the award you will have to incorporate this, you to hear this objection and pass an award.
Lord.
That award may include that I am not passing the award in favor of Mr. Mohanto. I am passing this award in favor of him.
Lord.
That is that order will be that what is there, his determination is fine, no problem on it. But that must include in the award in terms of section 23.
Lordship is to see whether the award.
If award is passed, that is fine because see two situations. One situation is until and unless there is an award, what will he challenge in the referral court? This order cannot be challenged in referral court.
Lord. Because if Lordship go to my affidavit, there is a three types of three inquiries. On their behalf. They repeatedly claiming that because
You are not getting my point.
Lordship, I'm getting your Lordship point, Miller.
You are not getting my point.
Lord.
There may be inquiries, these, that, these are not our lookout. Final thing is that there is an objection. Okay, they are having inquiry. Whether that power is not there or not, we are not going for the time being. After hearing, he claims that I am person interested. The collector is within its right on the basis of material before him
Lord.
to say that no, you are not person interested. No question on that. But he must have a redressal, and that redressal, that the legislature in their wisdom has given that redressal. And if you correlate the section 64 and section 23, same issues. So how will he go to the district judge and say that this is the award? Where is the award? So therefore, your stand that section 23, there can be separate stages.
My submission is not that separate because since
No, that is your submission. That was your submission.
I am relying on because section 23 to 30, the procedure, how to acquire
An award is passed under section 23.
Lordship. No,
21 notice that
Lord-
23
Lordship,
hearing
Lord-
and award.
Lordship,
Isn't it?
award is section 30.
Huh?
Award
Okay, come.
Lord.
Award of Solicium.
The-
30 is award of kindly very clear. Shall make an award under his hand.
Lord.
In exercise of power under section 23.
Lord.
So your order, that order has been passed, which are saying that this is a determination made under section 23. There can be determination, but there is that award is not there. This is not the award. That after holding this is the amount, this is the award in favor of so and so. That is not there. So therefore, that order will go, and if there is already an award in the meantime, we'll say send him to there. Award is there.
Lord.
Where is that? Where is the award? This is not the way to pass an award. I want a certified copy of the award. Let the deputy commissioner. According to, you want to say that order dated 3/10/2017 is the award.
What is it? He said it's not.
Huh?
He said it's not bad.
Where is the award?
But the
My
debt has
people
to
has
be-
taken money.
That record to be produced by
This is the record.
even I have no information whether how much of money the respondent I appeared entitled for.
Have you? Because there is no award. What is the determination? What is the solicium? What is the compensation? Where is the award, madam?
Even in pin order,
See, this is a fraud upon the people. They are not aware what is the award and if this is the award. And everybody is signing tag number so and so, revenue receipt and taken money 28,000, 28 lakh 55,549. Somebody has taken so and so, somebody has taken so and so. Where is the award? That this is the valuation of the land, this is the Jira Tier 4 award.
so far
No, no, that is fine. Valuation should be there. They have done it. Valuation, they may do it in the prior to award also. That these are the persons entitled for this.
situation is perhaps one for
This order, if you say, madam, this is to be the award, this is an order relating to some individuals who has filed a claim.
Lord.
Award must include this determination and who has been granted and what is the amount, what is the solicium, who got against whom.
Why they are
Because what you have done is, you have acquired a land, determine a value on your own. Because since nobody has filed any objection, except these people.
Lord,
And what you have done is, okay, take money, like giving a flood relief.
my
Everybody has signed against that tag and part.
directly with the taxpayer.
my intention because that is even our name is not included in that tribunal because they
Now, on what basis you will challenge? Somebody will challenge.
okay, initially if allow me to comment initially amount of compensation was fixed 1 crore 22 lakh 23,814 and thereafter we object because we being the quarter of the land acquired, we object. Then it was enhanced by the authority.
This is prior to award.
Lordship, to 1 crore 78 lakh.
Okay, fine. That is not a
Lord.
problem. There may be.
After this came,
This is so far relating to the valuation.
Lord.
Isn't it?
Lord.
There is a difference between valuation and award.
because
That so and so is entitled for acquisition of land, so and so, so and so. Forget about you and him.
yes,
Where are the awards against others?
the duty of because
She is giving a Jamabandi, Xerox copy. Where is the land acquisition case? LA case. That the award will be there only. What is your LA case?
Lordship,
2011.
Lordship,
Five.
This can at best be receipt of money
Lord.
by the person interested in whose favor award has been passed. There
Okay.
will be a record.
One
All
more
LA
thing, Lord.
case number so and so, so and so.
Object to section five.
Objection, file, and this is the determination.
One more thing, my lord.
In fact, this impugn order was passed without mentioning our name. Petitioner unnecessary take us to, because they not even mentioned that we are entitled for that.
That is why. Where are you? Where is your entitlement?
Yes, my lord.
Where is your award?
Lordship.
Order has not come, they have received the money. There is no award.
Because of them,
Until and unless Madam can show that this is not a complete record, there may be some other.
So this efficiency activity is that
Though some record is produced, but this court has not found the award passed in land acquisition case number
Lordship,
Five.
5 of 2011.
5 of 2011. Inasmuch as the order impugned at best can be treated. This court is of a tentative view that the order impugned in the present case at best can be a determination which is required to pass an award under section 23 of the Act 2013. However, such determination rejecting the claim of a person interested, comma, the within bracket petitioner herein should be incorporated in the award itself in terms of the section 23, so that a person aggrieved can approach a referral court in terms of section 64 of the Act. MS Sharma, Learned Counsel submits that she will obtain the record pertaining to record in original pertaining to LA case number
5 of
5 of 2011, where according to the parties under which pertaining to the acquisition of land in question. The said record will only reveal whether in the meantime an award has been passed. Is this matter? Everything is in mess if this is the record.
very unfortunate.
It cannot be. It
I
land
agree.
belongs to some people. You give a government valuation, fine, and you give the Jamabandi name and revenue stamp and sign it.
Very
Somebody may want that, no, we want enhancement.
Take-
Forget about this dispute. Forget Mr. Bhagavati. Take note of him. Suppose he is having a sale deed of a nearby land, which is much more than what has been given. He want to establish that this is the actual value. I want enhancement. Where is the determination to show that this is the land value?
But Hindu, we are entitled
Hmm.
because of this letter. That
At least if there is an award, still you will, if it is award is in your favor also, still you have a right to go for. And there are certain issues, payment of interest. No, if solicium is a determination, but suppose award is passed today, actually not released, interest will be counted from which date? Date of award. Where is the date? Where is the award? Bhagavati? What lordship? Lordship will not do everything. No partner, no partner.
Because again it will open.
Sir, what focus of the
Okay. Okay. List after view. On the give it last part.
What are
the ninth, but
20.
Hello.
Dairy motor part.
Ato?
Mr. Mohanto,
Sir.
this is in fact, this litigation will help you.
because since 2018, my lord, after passing, after interference of this honorable court by way of interim order, I am helpless, my lord, because
I understand, but
I have doubt on if he doesn't have that amount. of
Lord,
land
if,
also,
if,
Lord.
if
no, he is happy with signing the Jamabandi. Only needs a what do you call revenue, revenue stuff.
Lordship, if Lordship had to exercise the jurisdiction of civil court, then Lordship will find what is their case. His case, land
No, that we cannot.
lost,
That we can.
because
See, therefore, the referral court, a district judges court is designated as a referral court.
Lord,
So that it has the, it is having, even, I could not find out the judgment in Baxi's case. The Honorable Apex Court says that including the title in this type of cases is to be determined by the referral court.
because they inherited land, 1 bigger 3 kata something, since, from 1945, suddenly they make it 1 to 4. On that is the basis of
That can neither be decided by the collector
that's why
nor by this court.
Lord-
Therefore, the provision of
Lord-
section 64. But for the section 64, he need an award.
Lord.
That can only be challenged.
If an award is passed,
Uh.
and in the award, his case is considered, that the impugn order will merge with the
See, there is no problem on that. See, impugn order had it contain the award. We cannot find fault with the impugn order.
or other
Please-
way around. Other way around, if the award, if
Uh.
at all in the award is passed,
Uh.
and is considered, his case is considered,
Uh.
narrated,
Uh.
and then rejected, then that will do.
That will do.
That-
That will do. Even a simple liner that he is not an award or an award is passed saying that he is entitled. Then also, since he has already objected that I am also entitled, he will have a right to go to the referral court.
Yes.
Even suppose he has not filed objection, then also he will have a right. So reference is not subject to filing of.
It is not a precursor.
But for that you need a concrete. That this is
Then-
the award.
I have no information. Only
You can have moment stay order is vacated. You can go and sign the revenue stamp. That is his anxiety.
I entered it, entered when 8 minutes. Because after
But suppose there is an award, there may not be a question of stay until and unless the referral court passes. That you will have to address on the next day.
I just
Whether money can be released in terms of the award. Because there will be implication on the government. Until and unless it is stopped by a court, they are bound to release. If it is not released, he will come and say that give me interest.
because that must have if that
We do not know who
then
decides. but-
I will
Because these are the
certainly
very intricate
Is that
issues.
similar?
You will have to highlight it
Lord.
while arguing.
That-
That
that's
these are the issues. Madam will have to say, no, we will have to
Yes.
pay interest. Please clarify us whether we will release or not.
my
These are the-
affidavit, my enter
Okay. Next case.
The commissioner was directed to file an affidavit.
Oh.
We've written to them, not received instructions. As to how the land has been converted to pass.
But affidavit is there.
Affidavit is there.
Affidavit is there. It says we have made it fast. Okay, Mr. Sharma, Learned Counsel submits that he has not received the instruction in terms of this court's order dated 4/3/2024. And therefore seeks 2 weeks time to obtain such instruction and file an affidavit. Is this matter?
Lordship, yes, our additional affidavit regarding the order at 6:30 yesterday, which
Okay.
will be taken.
In the meantime, accordingly, prayer sessions, please this matter.
Uh,
After view after
30th, subject to the convenience.
30th of April 2024. It is raised to it is submitted with the Learned Counsel for application of an additional affidavit. Its file has been filed. Date
20,
was filed on 20/03/2024. Registry to verify.
right, If
Yes, what is it?
Please, my lords, I
Yes.
appear for the petitioner.
Yes.
My lord, it's a service tax matter.
Hmm.
My lords, earlier orders have been passed, interim orders, staying the impugned order. And the matter is now set for final hearing, my lords, in terms of earlier orders dated 28/7/23 and 13th of February 24.
After view vacation.
Sorry, my lord.
We are having a
Very well.
vacation
Yes.
for Bihu. So he's proposing to have it in the last part of April. You are enjoying a
Very
stay?
well, my lord. But yes, would my stay please continue then, my
I will extend your stay. Okay, is it fine?
Very
For
well.
any
And will
urgency?
my lord, we would like it disposed of early because it's covered by Supreme Court order and by board circulars in our favor.
Because see, next week, next week,
2 days that
next week there are 2 days. And thereafter, I'm not here for some time. So,
My lord may fix it at my lord's convenience.
okay. Pleadings are complete, na?
yes, meeting.
Yes, pleadings are complete.
Pleadings are complete. Accordingly, please this matter in the admission column for final disposal on give a date last part of 25th. 25th of April. Any inconvenience?
No, my lord, that's fine. I'm only requesting which can be earlier, but otherwise 20.
No, that we have already reflected.
Okay.
Interim order passed earlier at 30.
Grateful.
Hmm.
As per the last order, it appeared for the first time, and we were asked to bring the inquiry report. There was a report which was Lordship have got the report. Report, Your Lordship, starts from the third page.
What is the issue for seller? Go to the report later. What is the grievance?
So as per order, the honorable court, the AGM was held, and he has confirmed that the AGM is held, but it did not allow us to enter into the initial.
Hmm.
So the against the petition was filed. That the order of the then they raised question that the meeting was not held in accordance with the bylaws. That is why my lordship directed to make an inquiry.
The meeting was held on when?
Lordship was held on yes, my lord.
Now, meeting was held on 9/9/2022. Huh? Now, the deputy will have to file an affidavit by way of an affidavit. The report says, are you having a copy?
No,
The report says, let me disclose because the report says the general conclusion is this. General meeting was held on Rangamonson 9/9/2022 by Sri Sri Atkhelia Namghar Porichalana Committee formed a new management committee. One. B. Whereas all the process laid down in the bylaws of 2004, Constitution of Sri Sri Atkhelia Namghar was not followed. The Bor Barik, who is said to be the head of all Bariks, stated that Bariks of 24 khels out of 34 khels did not receive an invitation for election of the new Porichalana Committee or the general meeting that was held on 9/9/2022 by Sri Sri Atkhelia Namghar Committee. It is also to be mentioned that majority of the khels, that is bariks of 24 khels out of 35, have objected to the manner in which general meeting dated was held. When filed there, on the basis of this report,
Ultimate solution is the new
any provision in the bylaw challenging the election? Any forum is given? But how do we decide? How do you decide that who objected, who not?
Best thing will have a new election. That's not what.
Either new election or relegating you to file a civil suit for declaration that the election was good.
The terms is also over, my lord. Now, ultimately, people will suffer.
My lord, my all respect, let the Prime Minister could be so that I can object.
No, tell us one thing. Period is also over.
Over. 2016 to 3 years 19.
So, my lord, Prime Minister,
So then what remains? Why should we have an
They've
inquiry?
done, they made amended the bylaw over 5 years. That is over in 19. From 19 now 4 years have gone.
they are disturbing pages, maybe.
No, where is your election? Tell us. To us. No, where is your when your period started?
My lord, from the new election period is not 25 years. They said 3 years.
As per the amended one,
As
not
per
by
the
board.
amended one, my lord, why I request that.
Anyway, who is now running the show?
We are running it. We are the Police Committee.
Then why are you here?
They did not open the law inside the room.
You are Porichalina committee. Who are the?
He did not
Who
open
can
the law.
stop you from?
My lord, kindly.
Who locked the? Who locked?
Deputy
Commissioner.
One lock is open. The one lock, my lord, when the order is passed by the Honorable Court, the other lock inside there is a room. Advisory committee meeting. Just there you may be sitting.
If the term is over, fine.
No,
5
it is
years
not
back.
over. There are
5 years.
Now what to do? Let him file an affidavit.
Yes, I said.
Huh?
Because we don't have copy the report out.
Okay. In terms of this court order dated
13.
no, not 13, 25/9. 25/9/20.
Yes, 25/9.
25/9/2023. Mr. Fukan, Learned Standing Council for GAT, has produced the inquiry report on the management committee election of Atkelia Namgarh. Uttar. The said record, amongst other, reveals that the election was not held as process laid down in bylaws 2004, and that majority of khels, KHELS, that is bariks of query 24 khels out of 35 have objected to the manner in which the general meeting on 9/9/2022 was held. In the aforesaid, in the backdrop of aforesaid report, let the report be brought on record by an affidavit, so that the petitioner can respond, make a response to it. List after due. Let it remain in the ventilation. When is the overall term will over?
It's unlimited.
Unlimited.
There are another
19 to 5 years.
There are another page.
Keep it, my lord.
Page 8 will
Huh?
confirm.
Okay. A copy of the report is kept on.
Another copy with
That
I'll
is
make
what.
I'll make an affidavit, my lord. In the form of an affidavit, I'll keep it.
copy may be filed to be.
My lord, that, my
So
lord,
that I
this is
can
between the
Let
court
them
and
file an affidavit.
my lord. Deeply noted.
My lord, let them file a copy, extra copy to me. So that my lord, I can stop my client.
Admitted that in the case in hand, DNA profiling has already been done. However, the investigating authority is awaiting for such report from FSSF. What is about the other investigation? As a whole investigation
Going on.
okay, and the investigation regarding the allegation of rape. Thank you.
you have deposited the method that adjourned and be listed after 3 weeks, on the next date, it's going to learn it, in public, that apprise the court regarding,
Report.
status, up to the status of DNA profiling, registry to list this matter reflecting amount. Around what was this here?
My lord, here it was there. That would be required at the time of construction of Surusajai Stadium.
Hmm.
There, what happened with the side of that? The question was onward. What is that they're about to give land? The proposal was going for the RDA taken. Just the plan, it was their land.
Okay, in exchange.
And this ultimately two decisions were voted. One first decision was on this. I think the best I've made everything, but first decision on our would say the division not filed to dispose of it. That's what was going on for division fighting. I think again, second decision in 14. That is what letter was there. Letter was there on that letter basis to dispose of the thereafter, government has taken decision and 4 members committee also formed that they also decided that some plan should be given. This all this here, Millard. Now ultimately, Millard, what happened in 2000, here we have why again we have told your lordship because of it was 24th May 2022. It was the first about correspondence then circular which has given to ADC that legal letter can be allotted. Thereafter, the letter has gone for ADC. You have to see again because the land may not be available because it's already been allotted to allotted for construction of hospital and all that. That is the way for lordship. Now, all along it was my lord for considering for a change of plan. There is a bad hour after that. The government was taking from now neither Naftel, neither we are getting land,
What is
nor we are getting
your
compensation.
Your stand.
Now the district files an affidavit here is saying that there is no government land, that amount of land. Is 32 weeks. That was the proposal. 5 feet and some letters were referred. I don't see now the trend is that there is no land.
How will
Either lordship, there is no promise. There is no promise. Only one letter from the circular.
no, but ultimately decision admitted position that their land was taken.
Yes.
Yes.
Five
Either-
figures,
5 figures.
2 quarters.
Whatever it will come. It's a source, but the idea is
So therefore, in lieu of that, you propose them to give a land somewhere else in the,
no, not Guwahati.
not what.
We don't propose.
Somebody proposed,
Yes.
but land was given. Your agent proposed that. So if you are
Either
give
compensation or
the compensation today's value, not on that value, because on that day you are supposed to pay, because the
Because
moment you start a
everything-
land acquisition,
the compensation amount that was assessed award after the award that was assessed and the award was passed. Those
what was the award?
it
Because
is
the award is written,
about
I cannot get.
my lord.
Now, then there may be some deliberation is required. Say, then it may be question, okay. Award was already there, this was the amount.
Right.
When it was, just a minute, what was the year?
2003.
2003. Now, what will be the
and the
statutory interest till now?
statutory interest will be after award, my lord, 9%
9%.
first year and after that.
Okay.
Okay.
So that may be their
That apart, my lord.
Ah.
That apart. Now, what I find limit the knowledge I have submitted.
admittedly from the heart in the heart of Guwahati, 5
Yes.
bighas, 2 bighas land has been.
Right.
That state will not expect state that this is not a promise. If this is not a promise, okay, we'll report will
Not you
handle
will
it.
decide on that point.
Either
I have given all documents.
because
Now, whether it can be state promised or not.
When we'll decide this matter? Now it is a final decision is
Yes, my
required.
lord, lordship. Okay, my learned
go
friend
through
has
the
put
record,
that
not
record.
today.
I have
Not
hurried
today,
it out.
Mr. Borua.
No, that's well. No, I very beginning I told him because it's not possible. He has to go through it.
Ah.
It is a question of public exchequer. Yeah, I should not get 1 rupee more and I should not get less 1 rupee less also, my lord.
So there may be different options and all.
Yes,
Uh,
my lord. Only
What can be?
only my submission maybe it will help. But submission will report not as if my learned senior friend is saying the land is not open, then definitely your lordship saying it is not disputed fact that the land is open. How much, but whether it will come after coming fair compensation act I think 2013, for those for this payment was not taken.
So
It
all
is also
this,
be looked into. And if it is so 100% solution will come, then all these things will lot many question will come.
that may
This
go much more than
way,
what.
Lordship, if
But
it is saying say today
finding
itself,
that kind of document and that amount of document is very difficult.
correct.
Which suggestion was 30.
There may be some rethinking that okay, not
Yes, no,
35
not
because
last
some less.
Those can be.
Those can be explored, but we want that the person who he should be adequately compensated. He
Yes,
should
my
be
lord.
just
This-
compensation.
Even
What is should be the just compensation? It may not be 35 because maybe less.
it has gone
maybe
to, my lord, even 2010.
it cannot be the same land exactly. We will also not say no that
Yes,
land is also already.
No, it has come to 15 figures. So it is 15 figures. It's
Okay,
own letter.
it is submitted that record of LA case number 3 of 2003 as uh, is, is received. However, the learned senior counsel submitted he may be allowed some time to go through. You want to look into the record?
No. What
If
I'll
you want, we
understand-
can give you.
what I'll understand, my lord. Let him understand first. He is my friend.
He is most welcome.
He is my friend.
Okay.
We are here
The
for 14.
petitioner also may, the learned counsel for the petitioner may also go through the record.
Only on what can
Give a date.
it can be one of the only observation related to your lordship.
No, we are not making any observation on
Today.
next date
Yes, yes.
because earlier orders reflects everything.
Because I have been he's saying that no, he's not going to pay it to the man will give a compensation. That unofficial
And also, my lord, after going through the record, I'll have to advise my class.
yes,
to
if you
explore
want to
the
advise,
possibility.
If you can have it.
I'll also take
Okay,
suggestion.
we are not taking anything today. Okay,
yes,
give a date
If
after
your
Bihu.
lordship convenient, because it is he
No,
will
no,
be
after Bihu because their officers will also be busy for the election and all.
now again it will
Again, it will be adjourned.
that will be better after
In the
election.
first week of May,
After 7th of
after 7th of May.
of
this-
May, a hearing is
Give a date. 9th of
published.
9th or 30th. Because
Election
9th May all will be exhausted. These officers will be exhausted.
this night, that is at 14.
16th.
CJ.
Yes.
Public.
Yes.
That upright and illegal construction, protocol over route for construction it is freedom.
Hmm.
I think on restricted.
Yeah.
Responsible by the associate. Next up, the page 25,
Pay annexure 3.
page
25.
25. Okay.
That is, it is 10 was 29. It was for deep the street, number 4, right for and unit 4. And 510 is the space 26
Now NOC is for how much?
for building construction. That is
No,
for
no.
deep the street.
Huh?
Deep the street.
G plus. Now according to you, they have in violation of NOC they have got.
They have constructed deep the street.
Now what is the stand of the same the authority?
TMC have
Huh?
report
Demolition started demolition.
that is the fourth floor. They have not produced the NOC document. Only a certificate has been produced. Hello. We'll get
You
that.
be happy with the 2 floors. But you want to demolish 4th and 5th. Now he is having 5th and 6th. He is having 3rd, 4th you have regularized.
Well, pilot, in the meantime, we have applied for before the appellate authority of the GMC, my lord, that it may be regularized now because it is regularized because on if FAR is there, FAR is there, my lord. In our humble sufficient, FAR is still there, my lord. Authority may consider for
No,
regularizing
only
on
the
this.
affair is not an issue.
Yeah, permit is only for
Huh?
only for the affair can be accepted.
No,
But already
No,
they
that we understand, but tell us, can we decide all these things? You have
GMC
an
only has to do all these things, GMC, my lord.
no, not by him, maybe somebody else. Not tomorrow, after Bihu. Why the house be why the house be demolished?
No, no,
Why the let the
no, my house is under threat. No,
let the happiness of status quo as on date.
my lord.
Already they are not order, but officially GMC also looking into okay. High Court is going adjudicating
looking
this
at
matter. Let us not do anything. This is the situation. I think so.
but I am surprised.
No, actually,
No status quo. That you are thinking okay. High Court is deciding. Let us not demolish at this point.
no, he is suffering. That is unable to believe. I don't know how he is suffering.
Because my permission is pending.
Permission is pending, my lord, because he is not because your lord.
I have already applied.
You
Applied,
want
and
to
that is
you also want G plus C.
if that is allowed, then it's okay.
Then you want to withdraw.
If I am not allowed to not people sit, then it's okay.
Up to 4th floor, my lord, everything is okay.
No, not okay.
Who is your
Certificate is there,
builder?
The NOC is not there.
Who is your builder?
My lord.
Who is your builder? You have given it to builder.
Yes.
You have given it to builder.
Builder, my-
Let the builder bring. Let the plot be joined, and you have the
Still join, my lord. Still join, my lord.
still join.
He is given a NOC to me, my lord. Now says that is false. Now, if I am not giving NOC to him, he cannot build. And if he cannot give an NOC to me, I cannot build. So, but he has already given NOC to me. Up to 4th floor, my lord, we have, my lord, it is a permission has been granted.
No,
And now,
only the certificate.
He could understand in later on.
my lord,
See, I have given my affair in the name of NOC.
if my lord, if two brothers, my lord, they have not, my lord, compromised, my lord, that it will be difficult for my lord, both, my lord. But in case of me, my lord, he has already given my lord.
He is
NOC.
now saying this is I have
Now
not
he
given.
cannot, my lord, revert back. On the basis of his, that, my lord, we have got up to 4th floor, I get it, my lord. Yes, 5th and 6th, my lord, that is adjudication is there, my lord. That, my lord, that is actually there is a order passed by the Mayoral Council to consider my case. Actually, my case is that till that, my lord, that they let the regarding 5th and 6th floor, my lord, Mayoral Council, there is an order that they will decide if it is permissible, they will allow it. Otherwise, we can demolish. So till that, my lord, that authority has not yet taken in this. Until that, actually, we
Before
are,
that, you will have to satisfy that this is permit because in terms of Priyanka,
no, Pionka is not
No, no.
applicable in case.
no. In case of Priyanka, no, we are not saying Priyanka. In case of Priyanka, the law is that whosoever may be the authority,
My lord.
you might have a power to grant permission, you might have power to grant relaxation or regularization. No problem on that. But you cannot give beyond the provision of right.
Exactly. That's why, my lord, after Pionka, my lord, very authority also very clever, my lord. They amend, my lord, one line has been incorporated. I am taking benefit of that line.
What is that line?
That
They say they can give beyond.
yes. Now that additional extra floor to accommodate area within compoundable
Subject to
Not additional of extra floor, not additional extra.
additional of
Of
extra floor. So extra, if I build a extra floor, if it is permissible, that floor area is maintained, then authority can consider. That line was in earlier 2014 amendment, 2004 amendment, it was not there. That is being into the notice.
enjoy the bihu.
Actually,
Enjoy the bihu as is fair basis. You are enjoy. You'll enjoy.
but one thing, my lord, if they have two brothers, my lord, if they are not my lord, compromise, both are loser, my lord. Both are loser. Because it is as Ismaili Pata.
Already he has constructed. I'm not getting the required effect.
So let his be demolished, let there be equal port.
Yes.
This is the case.
If there is
When
a lot-
brothers
No,
fight,
my lord, problem is that, my lord,
only when brothers fight, God help them.
yes, my lord, the court cannot.
God cannot.
Court help us, my lord.
On the prayer of the learned council for the party, this matter after people.
Well.
Let you intervene, you be the mediator.
My lord, difficult, my lord. Difficult. It is, my lord, if it is outside, my lord, that will very good to conceal, my lord. If between two brothers, very difficult.
And Nayak is waiting.
He is enjoying.
You know, he's waiting to demolish.
No, that was
No,
appeal.
that is only limited protection till the by appeal. All. That's why, my lord, I want to, because what happened, why I am loser, my lord, even they are not allowing me to work up to 4th floor, my lord, where already, my lord, permission has been granted.
But
Now he wants 520.
That I absolutely agree, absolutely agree, my lord. That is under their
Suppose these are all stories, golpo. This is Puriyai Hati. Isn't it?
No, actually, it's true. If you going construction, keep on going.
So suppose his 5th and 6th is demolished. What benefit he will get?
I will get the effect.
So why?
But he will not get NOC from me because it
No,
is
no.
Ismaili Pata.
No, I understand. But problem is this: you be happy with up to
No,
port.
actually, I'll try to-
Let him not.
Yes,
disturb,
I'll try to
let
sort
him
it
not disturb the port at least,
That means that
and let him have
no,
the.
suppose I may be allowed to up to 4th floor, no, without any hesitation. Then if he get some up to 4th floor, if he get permission, my lord, then I will try to compromise it, my lord. I'll try. I will try because it's two brothers, my lord.
See, suppose he has given an NOC to his brother. Now that
Why not? Why not me?
that is becoming boomerang for him.
So difficulty is the two pillars are different. His pillar is also different. My pillar is also. All right, I'll to fight.
Do you
Because
get this
yes.
point?
Yes. So otherwise, both sides are loser.
Because he has given you NOC.
Yes,
So he has now.
I have not given to him.
He's not. You have not. At least he's
Yes,
entitled.
yes,
Proportionality, Mr. Nayak. So we are doing panchayat here.
All right. I'll try to pursue my
That is a better way.
lord.
Since-
Otherwise, my lord, the poor my lord who booked the flat, my lord, they will be at suffer, my lord. The person who booked his my lord, they are,
But in Priyanka Estate,
my lord, I have seen.
even Supreme Court has said that go to civil court.
It did not done that.
So that could have been a compensation from the
Compensation, my
builder
lord.
that we have told it. That is also not done. We do not know what happened to them. Yes,
All right.
after-
But
Give a
after
date.
date,
Give a date convenient. Now you have the Bihu celebrated together
I attempt to do this.
this
I'll-
time. Resolve their issue and
Resolve
come back
come
and
with a
say that,
good solution, then I'll.
and so that we need not go into that who is legal, who is illegal.
Better not. to
Just
that,
you
yes.
come and say that a merit petition should be allowed to withdraw. Moment we enter, we'll have to decide as per law.
Develop.
Yeah.
I think I am representing it. It's too bad.
Huh? 35 to 30. Yes, and you want to raise a maintainability?
And yes, maintainability as well as the jurisdiction.
Okay. So let him argue first, then we'll go to the merit. Maintainability on the basis of jurisdiction or
No,
both.
no, no, jurisdiction because the
It's a
ESIC
cause of action is in a different
Right,
state.
different state.
Okay, and maintainability?
The alternative provision is a provision for EI code in case of
Okay.
in the repetition 4139
You are for ESI.
in the ESM phone number 1326.
Okay. Okay, let us, what is the challenge here?
The challenge is page 26. They have challenged the demand notice.
Page not 26, it may be 27.
I'm sorry, madam.
27.
27. This is the demand notice they have sir. And madam, this is issued by the regional office Tripura at the top of the notice, sir.
Okay.
Under section 45C. Yes. If a lot. Yes. And I'll come to the case. As well as madam, page 28.
These are the
Under challenges. Again, madam, your lordship will find that it was issued by the regional office. And my lord, the provisions of the ESI Act in Tripura came into force by the Gazette notification in 2008, which one I have also filed in my affidavit in opposition, page 40.
Okay.
Page 40.
Page
14 of my affidavit in opposition. Now, page 14 of my affidavit.
Yes.
This is the notification where the applicability of the ESI came into force in the state of Tripura. 2008, it will be in effect from 2009, January 2009.
9.
And now, Mr. Lordship peruse the section 1 of the ESI Act, section 1, 3, and 5.
Section 1.
Section 1, subclause 3.
Section
1, subclause 3, and as well as the subclause 5.
Okay.
Section 1, subclause 3. It shall come into force on such date or date as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for different provisions of the Act and for different states from different parts thereof. Exactly this under this section 1 3 the SIC Act was the applicability of this Act came into the state of Tripura, and my lord, section 1(5). The appropriate government may, in consultation with a corporation, and where the appropriate government is a state government, with the approval of the central government, after giving 1 month's notice of its intention of so doing by notification in the official gazette, extend the provision of this Act or any of them to any other establishment or class of establishment, industrial, commercial, agricultural, or otherwise. Like here, my lord, at page, even in page 15, my lord, to official gazette notification published by the government of Tripura, the act was again came to was extended at page 15.
Yes.
15 of my affidavit of birth.
Okay.
These are the with this notification, the act came into Tripura. Here I am telling to the jurisdiction. The notice which they have been challenging is issued by the regional office in Tripura. The establishment of the petitioners is also at Tripura, Malad. So the cause of action, Malad, everything if there is any, it should be in the state of Tripura.
Okay.
And I'll, in support of that, I like to draw some few judgments.
They have challenged here because there are some direction to the recovery officer
Hello.
who is situated in Pamunimai.
No, Malad, Pamunimai is the regional office.
Ah.
Malad, in the other demand notice, it was issued by the regional office in Tripura.
Okay.
When even if they agree by it, Malad, I'll come to the
Now, what is that page 27 in the writ petition?
page 27, Malad, is the
Recovery of.
recovery of it. That to recover the amount.
So therefore, I think they have chosen this one.
Mal-
Is it not? Is it not? Is it not, Mr. Counsel?
Yes, my lord. My lord, may I also see page 33? There's a recovery officer notice to the banks where it says that given under my hand and seal at Guwahati.
Okay, we'll come. Okay.
Yes, my lord.
Now, these are the judgments you want to rely.
But not all actually, I want to give a part because the first judgment is with regard to the jurisdiction. But
Okay.
before that, and also I'd like to invoke the provision of section 20 of CPC, where the
Okay.
cause of action.
Now,
Right.
this is a notice. What is the impugn is notice is one is the recovery officer,
Recovery
petition for recovery,
27,
and
28,
other is
28, my lord. These are the proposed notices, information regarding to pay the KSI.
yes.
But then
Then
before that, also include the provision of section 226 as well as the section 20
Constitution.
of the Constitution, as well as the whatever dispute remains, even if it dispute remains, the proper place, proper appropriate court to the
High Court.
Tripura. Section sub 26(2).
Yes.
I didn't get it. Lordship is after the court has the power to give any direction. Notwithstanding that the
wholly or in part.
wholly and part arises such power, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. Malad, in support of the on this judgment, Malad 1007, 11, and 3, it's the first para.
Can you repeat the?
Yes.
There is some.
2007, 11 SCC 335.
335.
Print out has been carried out from my friend only. This SCC in different page. And it's para 16. Para 16, Malad. I'm relying on para 16, 18, 19 to 22 and 23. I'll read on para 16.
Paragraph.
Paragraph 16, 18, 19,
Just
16 to 22,
16.
then 37. If I read paragraph 16. It may be stated that the Constitution, 42nd Amendment,
Paragraph 20.
paragraph 16, you may satisfy the Constitution, the underlying object of amendment it was expressed in the following words.
under the existing Article 26 of the Constitution in India, and the only High Court which has jurisdiction with respect to central government is the Punjab High Court. This involves consideration hardship to litigants from distant states. It is therefore proposed to amend 226 so that when any relief is sought against any government, authority, or person or any action, the High Court within whose jurisdiction the cause of action arises may also have the jurisdiction to issue appropriate direction, order, or writ. And paragraph 19. The question for our consideration is to whether the assertion of the appellant is well founded that a part of cause of action can be said to have arisen within the territorial jurisdiction of the High Court of Punjab and Haryana, whereas the appellant commonly supplies that a part of the cause of action has arisen within the territorial jurisdiction of that court, respondent contest otherwise. The respondents there resides in the court of state of Sikkim matter. 21 months. The classic definition of the expression cause of action is found in so and so, wherein Lord so and so said, cause of action means every fact which it would be necessary for the plaintiff to prove if transversed in order to support his right to the judgment of the court. For paragraph 22, for every action there has to be a cause of action. If there is no cause of action, the plaintiff petition has to be dismissed. Then coming on to the conclusion of this judgment of this Supreme Court, my lord, paragraph 37, my lord.
Yes.
From the aforesaid discussion and keeping in view the ratio laid down in a cantina of decision by this court, it is clear that the purpose of deciding whether the fact averred by the appellant petitioner would or would not constitute a part of cause of action, one has to consider whether such fact constitutes a material, essential, or integral part of the cause of action. It is no doubt true that even if a small fraction of the cause of action arises within the jurisdiction of the court would have territorial jurisdiction to entertain such petition. Nevertheless, it must be a part of cause of action, nothing less than that. 38, my lord. In this present case, the facts which have been pleaded by the appellant company in our judgment cannot be said to be essential, integral, or material fact as to constitute a part of cause of action within the meaning of Article 226(2) of the Constitution. The High Court, in our opinion, therefore, was not wrong in dismissing the fact. I can realize the fact, the order, everything is Tripura, the cause of action lies in the state of Tripura, and the honorable work is the best to educate us. Now, I'm also informing the section 20 of PC power. Yes, section 20. Other suits to be instituted where defendant resides or cause of action arises. When this provision is also been explained in referred here, it is subject. If I may, subject to the limitation aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction the defendant or each of the defendants, where there are more than one at the time of the commencement of the suit, actually and voluntarily resides or carries on business or personally works for gain, or any of the defendants where there are more than one at the time of the commencement of the suit, actually and voluntarily resides or carries on business or personally works for gain, provided in such case either the leave of the court is given or the defendants who do not reside to carry on business or personally work for gain as aforesaid acquiescence in such institution or the cause of action whole or in part. Here my explanation is also given, mother. A corporation shall be deemed to carry on business as a sole or principal office in India on respect of any cause of action arising at any place where it is also subordinate office is such place. Here. Since all the accounts and all the tally books, it's in the establishment of petition is in Tripura. So, yeah. And coming to the next, maintainability. And section 75 of the ESI.
Section
75. Yes. In what, in case of disputes like this, which is the appropriate court to decide such section 75. Matters to be decided by employer, and court. Matters to be decided by employers insurance court. If any question or dispute arises as to whether any person is an employee within the meaning of this act and whether he is liable to pay the employee's contribution or, but I'll just come out to the at G, section G. Any other matter which is in dispute between a principal employer and the corporation, or between a principal employer and an immediate employer, or between a person and the corporation, or between the employee and the principal or immediate employer in respect of any contribution or benefit or any other dues payable for recoverable under this act, or any other matter required to be which may be decided by the employer's insurance court under this act. Such question or dispute subject to the provisions of this subsection 2A shall be decided by the employee's insurance court in accordance with the provisions of this act. So when a special court has been constituted in related to the dispute in the like the present case. And section 375 subclause 3. No civil court shall have the jurisdiction to decide or deal with any question or dispute as aforesaid as to adjudicate on any liability which by or under this act is to be decided by medical board or by the employee's insurance. And note the civil court is also part to entertain in dispute regarding the employee's insurance court. And section 78 has been dealt with the powers of the employee's insurance court. 78 deals with the powers, and the employee's insurance court shall also be a civil court, as CPC will follow. And my lord, in case when the statute is clear, in case of dispute, petitioners are the principal employer. In any case of dispute between principal employer or immediate employer or the
corporation.
or corporation,
corporation.
EI court and all the EI court also there in state of Tripura. And regarding matters like this, this honorable court in a number of cases I've given also refer such matters to EI court. First one is WPC 2772 2016. In the list of national lottery profit. 277 to 2016, 981 22, 554 2018. And these are a few cases where many lottery will find in cases of disputes regarding the principal employer corporation. The matter has also always been referred to the EI court in order to repeat it. I'll not read it out. Including one. Hello?
Read one.
My lord. And I'll read the small one, my lord. In 98122, my lord. In WPC 981/22. Order dated 16/2/22. And has also got it.
Yes.
Third, Mr.
Order at 65.
My lord.
Which order you want to read?
WPC number 981/22.
Okay. Listen.
Listen. From 16 2016, I'm referring only to future case. Third, Mr. So-and-so, line paragraph 22, paragraph 2. The writ petition under 236 of the Constitution of India has been prepared by the petitioner, assailing a demand notice to defaulter dated so-and-so, issued by the respondent number so, and a prohibited order dated so-and-so, also passed by the respondent number 4. On perusal of the notice of demand dated so-and-so, it transpired that the state notice was issued under the provision of section 45(3) to 45(1) of the Employee State Insurance Act, so-and-so. Same notice, my lord. With rule so-and-so of the income tax. The prohibited order dated 14/7/21 has been passed in purported exercise of the powers, section so-and-so to so-and-so of the ESI Act 1948, read with rule so-and-so, procedural of the Income Tax Act, due to the failure on part of the petitioner to pay the arrear due in respect of the certificate bearing number so-and-so dated so. Having gone through the provisions of the ESI Act 1948, it is noted that the section 74 of the Act has provided for constitution of the Employees Insurance Code. Section 75 of the ESI Act has provided that for matters which can be decided by the Employees Insurance Code,
The learned counsel for the parties are not in dispute. The issues raised in the writ petition can be decided by the Employees Insurance Court. Can be seen that the subsection 2 of the 82, the ESI Act has provided for an appeal to the High Court from an order of the Employees Insurance Court if it involves substantive question of law. And this court can only entertain money under Article under Section 82 as a form of appeal of the order of the Insurance Court. Mr. So-and-so has submitted that the petitioner has been undergoing severe financial constraint during the last 5 years and also has been suffering from different ailments. If the petitioner approaches the Employees Insurance Court for adjudication of the issue, then the petitioner has to deposit 50% of the amount due to be due from him by the respondent ESI authorities as per Section so of Section 75 of the ESI Act 1948, which is not in a position to comply at present. As this is important, as there is statutory remedy is provided under Section 75 of the ESI Act 1948 to the petitioner against a notice of demand dated so-and-so and a prohibitory order dated so-and-so, the petitioner shall approach the Employees Insurance Court by way of an appropriate application. The provision to subsection 2B of the Section 75 of the ESI Act 1945 has made a provision for waiver or reduction of the amount to be deposited under subsection 2B of the Section 75 of the ESI Act 1948. The provision has given the authority to the Employees Insurance Court for reasons to be recorded in writing to make such waiver or reduction of the amount. The petitioner has the liberty to make such prayer for waiver or reduction of the amount with all the supporting documents, and in the event such prayer is made by the petitioner seeking waiver or reduction of the amount to be deposited for the Employees Insurance Court, the Employees Insurance Court shall consider the same in accordance with law and by taking into account the facts and circumstances contained by the petitioner. In view of the ability of such alternative, efficacious, and adequate statutory remedy, the writ petition is not entertained, reserving the liberty of the petitioner to approach the Employees Insurance Court seeking redressal of his grievances in accordance with the provisions of the ESI Act 1948. Same in other cases also. In fact, I've also given one judgment of the, even though it's not binding upon a lawsuit, by the Telangana High Court also, in petition number 3176 of 22.
Which is by
the Telangana High Court. The same observation. And also like to in last year like to cite only one Supreme Court decision regarding to this 2000.
that is Arijit Prasad.
No, the Santa Kumar. ESIC versus PC Santa Kumar. That's 2007 1 SCC 584. When I
2007
1 SCC
there are
584.
two Supreme Court judgments are there. One is
The last one is regarding the fact which I'll show it later.
2007.
But 2007 1 SCC 584. The ESIC versus PC Santa Kumar. The first one.
Okay, please Santa.
Please Santa. Like, you have to be relevant paragraph at
Para?
Para 21. Let me read my paragraph. The legislature has provided for a special remedy to deal with special cases. The determination of the claim is left to the corporation, which is based on the information available to it. It shows whether information is sufficient or not, or the corporation is able to get information from the employer or not. On the available records, the corporation would determine the area. So the non-availability of records after 5 years as per the regulation would not debar the corporation to determine the amount of area. Therefore, if the provision of Section 45A are read with Section 45B of the Act, the determination made by the corporation is concerned. Then the determination made by the corporation is concerned. It may not be final so far as the employer is concerned. If he chooses to challenge it by filing an application under Section 75 of the Act, if the employer fails to challenge the said determination under Section 75 of the Act before this court, then the determination under Section 45A becomes final against the employer as here. So it's referring to that all these independent question of fact regarding how much to be paid, whether it is applies or not, in the principal employer corporation, the matter has to be referred to the EI court. Special court has been constituted under the Act pilot. And also, I have also cited different sections of this honorable court, where in matters like this, the matters have been decided to EI court. That is not something regarding to the jurisdiction, as well as the maintainability of the jurisdiction.
See, two aspects. Suppose of your argument. Suppose we hold that this court is not having it. We will not even go to the alternative remedy.
That is what I'm fixed for the jurisdiction and,
Ah.
and alternative
So
remedy.
suppose we hold that it is not maintainable, then we'll have to refer it to the
EI
EI court. But if we say that we don't have jurisdiction, then we cannot even pass an order to go for EI court.
My lord. But that is the prerogative of the petitioner, whether they want to approach the EI court or-
Even in the event. So this is your first maintainability.
my lord,
So we'll go to first. We'll let us hear him on this point.
Right.
Or you want to add anything?
no, it is not the-
Yes. Yes.
Yes, my lord, then my lord, first we will have to, would like to hear the issue on the jurisdiction part. And-
Jurisdiction for a time being, we'll take up it secondly. Now you give us on a maintainability that remedy under 70.
Alternative remedy.
Yeah.
My lord, that notification which has been shown, that was which just now my learned friend has shown that how the hotel has come under the ESI. Now hotel has come under the ESI in the year of 2010, and that too also for 20 employees, not for anyone lesser than 20 employees. Subsequently in 2011 it was made 10. Now, admittedly, the so-called notice which was issued to us was of 11 employees. And in the so-called notice as well as recovery order, the amount which has been deducted from us, that was done for the year of 2009. Now, question is, in the year 2009, whether the respondent had any jurisdiction when notification did not even
So
came.
your ground is that when it's a question of jurisdiction, alternative remedy
Absolutely,
will
ma'am.
not be applicable.
Absolutely,
that is-
ma'am.
that
I'm
is
relying
the-
on
that-
Whirlpool. I'm relying on Whirlpool.
Existence of section 75 and determination is not your issue. Your issue is that the when notice was issued at that point of time to come under the corporation under the act, minimum employee was 20.
My lords.
And admittedly, notice was issued for 11 employees.
11.
So there being no dispute, such dispute need not be referred to the PSI code.
My
Which
lord,
is
there
not
is one
even a
more,
dispute.
one more addition to it, that 20 employees, in fact, for the period of 2009 to 10, there was no notification only. For not to speak about the 20 employees. The 20 employees also came in the year 2010. So for that particular year, they could not have even issued notice for a 10 employee, 20 employee, 100 employees. So in that case, it is absolutely without jurisdiction, whatever they have done. So on that, this is not a case of factual aspect. It's an absolute question of legal interpretation. And when the notification was not there, so on that issue, my lord, I'll be relying on the Whirlpool judgment, which says, I don't want to show it to your lordship, the judgment which gives the three situation when alternative remedy is not a bar. Firstly, violation of natural justice. Secondly, when there is a challenge to the act. And thirdly, when there is a question to the jurisdiction. So when there is a question directly to the
And
jurisdiction.
fundamental right.
Yes, also fundamental right is also there.
Because in case of LIC, I think.
Yes, my lord.
In case of life insurance or Whirlpool, Oil India, some cases where it was said that 19(1)(g) when it was violated, then also it was.
Absolutely, my lord. In our case, it's an absolute violation of fundamental right also. For example, we are doing our business when the corporation was not even fallen under this category, and they have deducted money. They have restricted our bank account. They have prohibited our bank account. And with regard to
Now, what about your point about this territorial jurisdiction?
Yes, my lord. Territorial jurisdiction, of course, my lord only had pointed it out that the recovery officer was of Guwahati, Bamuni Moida. It is not that the regional office, yes, the head office itself is of Guwahati, Bamuni Moida. I'm not going into that particular side. I'm just saying that the one who has done the recovery, who has issued notice to the banks, who has prohibited my bank account, everything was done from the Guwahati. Now, my lord, the judgment shown by my learned friend there, it is specifically stated in the para 37. That's why I don't even have to show my judgment. It says that even a fraction of cause of action, if it is arising in a part of territorial area, that particular
Where
place will
are
have.
where are the impugned documents?
My lord, I'll just show the documents. My lord, kindly see the page 27 of my writ petition 4139.
This is impugned. Page 27.
Yes, my lord. 12/11/2013 is impugned.
Ah.
This is issued to the recovery officer of Guwahati. If my lord see page 27 at the top, to recovery officer Bamuni Moidan Guwahati.
Who has issued this communication?
This was issued by the regional office of Tripura.
Okay. Okay. This was asked to recovery. Now this recovery, where is the communications from recovery officer?
My lord, kindly see page 31.
So and another impugned order is 23/11/2013.
Yes, my lord.
Next page 28.
My lord. That was a so-called notice. In fact, in the previous case, I could not annex the so-called notice. I did not have. My friend has annexed in the affidavit in opposition, the initial so-called notice. So they have issued so-called notice for different period in a different timeline. But the recovery was done altogether for all the so-called notices. If my lord may see kindly, page 31. Page 31 is crucial here.
There was a stay or what?
My lord?
Initially there was a stay. No stay.
There was no stay. They have
Whatever
already recovered
demand we have
them.
made, they have already paid, madam.
Okay.
So now if they are other limb of the prayer is that for reimbursement and reimbursement, that they may approach the high court. I mean, regarding my friend is arguing that the factual aspect of the case.
No, coming to that. Just I'm good.
Madam.
We have not concluded our hearing. Just we are having a
We are
partial.
jurisdiction.
Don't
Madam,
worry.
My lord, page 31, may I just show page 31?
Yes, page
This
30
is the
I have seen.
yes, 31. This is the prohibitory order. So if
Huh.
this does not give a rise to cause of action, then because from here they have prohibited the banks. Who is issuing that recovery officer? Bamuni Moidam. They are prohibiting my bank not to they seize the bank account and directed them to release the payment. If in page 32,
Okay,
second
just now enlighten us on your merit of your case.
Malaz. Well, on merit, firstly, that's the primary issue that without jurisdiction they have issued the this.
Because assuming for a moment that
Yes,
we hold that this court is having a jurisdiction, part of the cause of action is there because recovery is issued. This court is having a jurisdiction. Then you will have to answer the other part. What is the issue here? Issue is the recovery.
Hmm.
Okay. Now it's a dispute between event corporation. According to them, it should be decided by the PSI.
Malaz.
Is not it? So what is the determination required here? Determination required is whether kindly tell me the dates.
My lord, may if they see page 28,
Hmm.
27 in third paragraph, page 27. The periods are mentioned for which period they have issued this.
Where is that?
In
You have so
when-
far not paid contribution as per provisions of the law and have also not submitted monthly details for the contribution September 2012. Is it not?
Not that one. The previous one, page 27.
What about 28?
28 is a subsequent notice.
Is it under challenge?
This is also under challenge because recovery order was made for this also altogether. They have included the previous as well as the second one
So
together.
it is up to the month of March 2000, March 2012.
April 2011 from January 2009.
No, from January 2009 to March 2000, April,
May,
July 2000, August 2012.
January, February, till 2012. August 2012. August 2012.
August, it is from 2009 somewhere.
Yes, madam. From January 2009 to August 2012.
From Jan 2009 to
August 2012.
August 2012. This is the period.
Yes, madam.
And next is September 2012.
To September 2013.
Next is September 2012 to 13, September 13.
Yes, madam.
Isn't it?
Yes.
So what was the law at that point of time?
During that point, yes, for the second Soko's notice, there could have been this hotel. If that will be totally different, that will be on a factual side. But then for that period, hotel has fallen under the jurisdiction of ESI.
Okay, fine. What was the employee?
But the number of employees, we have specifically stated that it was lesser than 10.
No, that will come later. What was the act prescribed?
Act also prescribed from 2011 onwards, it was 10.
10.
10.
So if it is a 10, allegation is 11.
Yes, sir.
Your whole case is that it is the 10, not 11. So isn't it?
My case is it is not. It cannot be 9. It will be 11.
No. As your voice is a little bit
breaking, or my lord, actually there is some network connectivity problem today, I guess. Is it audible, my lord, now?
now, yes.
Yes, my lord.
So you say that one period, that is from 2009 to 2010 or 11. 11 under the act, a hotel was not within the purview of the ESI Act.
Slight correction. From 2009 to 10, hotel was not under the purview of ESI. From 10 to 11 for 20 employees.
From 10 to 11, 20, and from 11 onward up to 13, it is
10 employees.
10.
Yes, sir.
Now, what is the period? Demand period ranges from 2009
to 2013.
2030.
Yes, sir.
Okay.
Yes.
So now the determination will be required. First determination, okay, if it is not 2009 is not 9 is 9, fine. But this amount sought for is
3 lakhs. They have included both the notification together in the recovery order.
So this notification at page 27, the demand is for 11 employees, 8250. Isn't it?
Hello.
Average wages, so international 76,684. Isn't it?
Which
page
one?
29.
Page 29.
Yes,
my lord.
76,684.
Yes, my lord.
Okay.
So that, of course, if my lord want to exclude, that can be excluded. That will be fair submission on my part.
So suppose there is a question. Ultimately, what is the calculation? What is the period? I think it will be
No,
determined.
no, my lord,
That
that is
can also be determined by the court that we did not did not have the because they have clubbed everything.
they did not have the jurisdiction.
You will be correct. Say that their notice demanding money for the period with effect from 2009 to 2010. They did not have the jurisdiction. That jurisdictional issue with that demand is bad for the reason that it was not applicable can also be determined by the ASI court.
Actually, if the type provided, if it's all recorded, evidence has to be brought in recovery.
My lord,
regarding
but
the
no,
determination.
For that, there may not be any evidence
My lord,
required. If we go by the act and the rule
My
that
lord,
this is not in the schedule, then perhaps that part you cannot.
my lord, but this aspect can be also determined by the EI
Ah.
court.
But here, what they have done is that they have made certain. You have club everything.
absolutely,
Means you have club everything.
absolutely.
So we will, if there is a dispute whether 10 or 11, and the notice, this is just a preliminary view of it. If that covers everything, so we can make an observation that when an institution is not brought or not is a part of the system, of course, that cannot be demanded. So court will consider.
That part that I have to argue, if the topic is going into the fact, that is the fact of the case. That part your topic observed, I have to argue on that part.
Okay. No, definitely. These are the
My lord.
tentative ideas.
And in my view, it is brought under the notification 2008. And as per the earlier to the prior to the amendment of the section 212, the 10 numbers was required in a factory or in a manufacturing. There are some judgment also.
So according to you, those specific hotel is not there. Where the hotel or what is the
Hotel and or where the manufacturing is there, includes restaurants.
My lord, they want to include hotel into manufacturing industry.
But
They
that
want
I have
they're
my
trying to
charges,
say
my lord.
that it's a manufacturing industry.
So if that is debated, I think you
My lord, that is
will have already paid
already
the
paid.
entire amount.
No, my lord,
Go
that
to the-
debatable issue definitely will have to be decided by your lordship, because that will be totally interpretation of the fact. Because my lord have seen in
No,
the
my
tax matter also, if they want to follow it under certain schedule,
But
they cannot
this
say,
is but this is a demand notice inclusive of all.
no, my lord, it cannot be stated to be a manufacturing industry. Otherwise, if it would have been a manufacturing
But that they may
industry,
argue in the AI court, my lord. That will be going to
No,
the factory.
AI court
I
will
almost
not cannot decide this part whether it will be falling under a manufacturing industry or a hotel. Hotel, of course, once they brought a notification in 2010, that apparently amounts that it cannot be falling under the manufacturing industry. Otherwise, what was the necessity to bring it under the notification?
Okay, let us proceed on the merit.
My lord.
Yeah.
Okay.
And only that part, my lord, regarding whether it is manufactured, my lord, only then I'll cite on one judgment.
Yes,
2000.
2000.
Supreme Court, my lord, 1993, 4 SCC, 36. 19, I have given.
That party name?
The party name is,
Santa Kumar.
no, my lord, GL Hotels Limited and others versus CC Sarin.
1993,
1993, 4 SCC, 360. 363.
Hotel, GL Hotel. Where is that?
Well, I have given it on my lord.
Ah.
That my lord.
3.
My lord, para 3. If I may.
Yes.
The main contention of the appellants before us was that the entire premises of a hotel cannot be treated as a factory within the meaning of the state section merely because the process of cooking food is carried on in kitchen, which forms only a part of the state premise. It was not disputed before us, though it appears it was vehemently argued before the High Court that the kitchen is a factory since the manufacturing process within the meaning of Section 2 of the Factory Test is carried on there. And then, coming to the section, para 4, my lord.
Yes.
The manufacturing process as defined in Section 20 of Act, whereby Section 2 of the Factory Act in as follows. Interpretation of this act in this act, interpretation in this act, unless there is anything repugnant in the subject of the context, a manufacturing process means any process for making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing, or otherwise fitting or adapting any article or substance with a view to use, sale, transport, delivery, or disposal. And these are the definitions. And sorry, I have also missed out the paragraph 2, madam. This is very important of this judgment. Definition of this act, unless there is anything repugnant with subject to subject, factory means this is the prior to the amendment. Amendment was 14 2011, this is prior to the amendment. Factory. Factory means any premises including the precedence thereof, whereon 10 or more persons are employed, or were employed for wages or any day of the preceding 12 months, and in any part of which a manufacturing process is being carried on with the aid of power or is ordinarily so carried on. Here, my lord. This is where I've been writing. Paragraph 5, my lord. Since the manufacturing process in the form of cooking and preparing food is carried on in the kitchen, and the kitchen is a part of the hotel or part of the precedent of the hotel, the High Court has held that the entire hotel falls within the purview of the state definition. We do not see any infirmity in the conclusion arrived at by the High Court, although we agree with Mr. Swenson with the reasons given by High Court in support of the conclusion are not at all valid. And in para 7, it has been said that the hotel comes within the purview of the ESI Act, even prior to the amendment. At para 7, in the middle.
Those who occupy.
Yes, those who occupy hotels do not depend upon food and beverages which are prepared in this kitchen. It is not possible to conceive of a service rendered by a hotel. Hence, it cannot be denied that the activity in the kitchen has a contention with activities carrying on the rest of the hotel premises. And finally, it has been observed the hotels come within the purview of the ESI.
Where is that?
It should not further be forgotten that the definition of certain premises or factory or certain activities as an industry exercise given in social welfare legislation like the present are necessarily artificial. The object is to do
Exactly, this was in my mind.
the object is to do the welfare
For
of
the welfare of the.
even for the purpose of going to the EI court, a party has to be made, a worker has to be made a party in the litigation. When the legislation is for the welfare of the in my activity of that various in my affidavit in para 6, I stated the all. And in the head note also, the hotels are factories within the meaning of section 212 of the Act. The head note. That's it.
That was the argument was that okay, kitchen is a factory, fine, but it cannot be extended to whole of the hotel, which was the argument of Solicitors. Court says, okay, this may be a very good argument, but for the inappropriate case, we'll decide. But being a legislature, we held that hotel will come on in the
And lastly, one last submission. Again, I'm pointing out to section 75G of the ESI Act that any matter which is in dispute between a principal employer and a corporation, the matter may be referred to. Yeah.
Yes.
My lord. I'm just going through this judgment, my lord. But then, my lord, the only issue will be if hotel was already there as a manufacturing unit or a factory as stated by, then what was the requirement again in 2010 to come up with a notification so as to include the hotel? That itself
Maybe
shows.
because of this
Amendment, my lord, we have been specific, but that doesn't debar us from going.
But in that case, they'll have to now demonstrate that how many were working in the kitchen and how many were working in the
So
hotel.
that again be a determination made by the.
No, Malad,
That we cannot decide. That is pure. That we cannot.
of course, that will be purely factual, but then another contention, my lord, I will just have to show another contention. Of course, my lord, I don't agree to this. I'll have to once go through it so as to verify, because otherwise, why I'm saying, because hotel, if it was or otherwise also it would have been falling under this ESI scheme.
So let us do one thing. Let us do one thing.
Yes, my lord.
Let me dictate a part of the order.
Yes, my lord.
What transpires today.
Yes,
then you go through this judgment and find out whether that appropriate case has ever arisen.
Yes, my lord.
Okay.
That I will look into it.
You look into, we are just dictating down.
Absolutely. My lord, another contention, if my lord want to hear one more point I have, I'll just, because it's a very short issue, my lord might like to record that also. They have specifically stated that they have conducted the inquiry, because if they don't have a record, they'll have to verify from after doing an inquiry. And they did the verification as for the record only. It was in the year of 2008 December. On that year, when that ESI Act itself was not implemented for this particular hotel, they have done the inquiry, and on that basis, they said that 11 number of people were working there. That's an admitted position. So what I'm saying is that for 2011-12, the subsequent period, what your lordship is saying that they will have a jurisdiction. So for that period also, the inspection of 2008, whether that can be made applicable. They otherwise ought to have gone in the year of 2011 or 12 to verify whether there was.
We'll record it is on next day.
Yes, ma'am. Yes, ma'am.
Third, Mr.
K. Chaudhary, Kaushik Chaudhary.
Kaushik Chaudhary, Learned Counsel for the Petitioner, and Mr.
M. Smith.
M. Smith, Learned Counsel representing
1 and 3 2.
Respondent number 1, 3, 2, 6. Respondent number 2, who is representing? Who is respondent number 2?
Ever Commissioner Tripura.
Okay. Anyway. How many repetitions?
3.
Three repetitions?
Similar.
We'll pass a common order.
Yes, ma'am.
No. These 3 repetitions are filed assailing an action under the action of the respondent authorities. Action of recovery initiated by the respondent authorities in purported exercise under section 45C to 45I of the ESI Act 1948, whereby an action of recovery, a preliminary objection as to the maintainability of the writ petition on 2 counts have been raised by the respondent corporation, respondent ESI corporation, bracket hereinafter referred to as the contention. The basic contention, because we'll forget everything on the next page. The basic contention raised by Mr. Smith, firstly, is that the petitioner is a petitioners are hotels, all hotels.
My lord,
Petitioner,
no, that's what, there are difference in facts. For the first and third petition, it's the same hotel.
Hmm.
The second is a distillery. It's not a hotel.
okay. The institutions are situated in the state of Tripura. They have violated the provision of the ESI Act in Tripura, and the initial action of inquiry was initiated at Tripura, and therefore, in view of the mandate of Article 226 within bracket 2 of the Constitution of India, this court may not have jurisdiction to entertain the dispute raised. In support of such contention, Mr. Smith relies on the decision of the Honorable Apex Court rendered in the case of Alchemist Limited and another versus State Bank of Sikkim and others, reported in 2007 11 SC 335. The further contention of Mr. Smith is non-maintainability of the present writ petition for having efficacious alternative remedy in the shape of section 75 within 75 of the ESI Act. Referring to subsection clause D of subsection 1 of section 75, Mr. Smith contends that any dispute between the corporation and the employer is mandated to be adjudicated by the ESI court constituted under the Act. And therefore, the issue of recovery or any alleged illegality thereof, including the issue of jurisdiction of corporation to issue such recovery process can be determined by the ESI court. Therefore, this court may not like to entertain this writ petition having efficacy of alternative. Full stop. Per contra, Mr. Smith, Mr. Chaudhary, learned counsel for the petitioner, submits that the order of recovery was issued by the recovery officer at Bamuni Moidam, whose office is situated at Bamuni Moidam, Guwahati 781021, as well as the bank, HDFC Bank, the banker of the petitioner was prohibited. In as much as a prohibitory order against the banker of the bank prohibiting and restraining and the banker of the bank was also issued by the recovery officer at Bamuni Moidam. That being the position, even if it is assumed that the petitioners or even though the petitioner office and premises is situated at Tripura, a part of cause of action, main part of the cause of action arose at Guwahati as initiated by the recovery officer at Guwahati.
Was initiated by the regional office Tripura to the recovery office.
To the recovery officer. We have said notice,
To the recovery.
prohibitory order was issued by the recovery officer.
The prohibited order issued by the regional office, my lord, and the initial the 12/1/2013 order was issued to the recovered officer by the regional office Tripura.
No, you come to page 34, Office of the Recovery Officer, Employee State Insurance Corporation, Regional Office, Bhavani, to the branch manager.
But that is there, but in
Yes,
page
so that
27.
is what I'm saying, even recovery order.
In earlier order, when the lordship has when the it was issued by the recovery officer, actually when page 27, the order was issued by the regional office to
Office
the
to
recovery.
the recovery officer. That will correct. Okay, and therefore, at furthering his argument, Mr. Chaudhuri contends that even if it is assumed that the ESI court is competent to adjudicate such dispute, this court, under exercise of its power of judicial review, can very well entertain the present petition, more particularly when the authority and jurisdiction to issue such a notice, to take such an action, not issue, to take such an action in exercise of power under ESI is questioned in the present writ petition, more particularly for the reason that hotel and distilleries in the during the relevant period, that is from the year 2009 to 2011, did not cover and did not cover the was not covered by the act. He further contends that for the period of 2009.
Can I just correct one thing? Distillery is actually not the issue. Distillery is a different aspect. It's a hotel.
Distillery, okay.
Distillery, my
not
lord,
the distillery, not the
only
distillery. Distillery will inherit later. Hotel.
That's the second argument for distillery.
It is his further contention that even when the hotel was brought under the purview of the act, at that point of time also, the minimum employees required to bring under the purview of the act was 20 employees, and admittedly the notice relates to 11 employees. That being the position, the authority did not have such. Countering such argument, Mr. Smith, relying on the judgment of the Honorable Apex Court in the case of GL Hotels Limited and others versus TC Sarin and others, reported in 1993 4 SCC 363, contends that the Honorable Apex Court has clearly held that under section 2 subsection 12 of section 2 of the act, hotels are factories. Hotels are factories. That being the position, the dispute, that being the position, the respondent were well within their jurisdiction to issue the notice. At this stage, Mr. Chaudhuri, while referring to the judgment passed in GL Hotels, contends that the GL Hotels decision was passed in the given facts of the said case, keeping the question open whether only for the reason or whether the entire premises of a hotel can be treated as a factory within the meaning of the said section merely because the process of cooking food is carried out in the kitchen. Therefore, he contends that he may be granted some time to argue further on this point. On this point, accordingly, matters then adjourned and we listed on.
One more thing that the
These are only to remember, nothing more, nothing less.
Regarding to the other decisions of this honorable Kushal paper statement.
That will be there. Today we have shortcut. Everything will be in here.
Anyway, subject to the conveyance of my learned friend. Your lord.
But after view, anything on it, because we do not want to decide today itself on this stuff. I want to also go through that.
If my lord agrees, if and my learned friend also agrees, can it be in the month of last week of May? Because otherwise, I'll be physically present there. If it can be possible.
No, it cannot go to May because we'll have to fix a date immediately because I'm keeping it as a part hard.
My lord,
It should be within a month.
Yes, madam. Then on a Wednesday
Then, or you have some, you'll be busy with election, but what?
no.
I don't know about my lord.
That seems, that's why he's seeking
My
me.
lord. Maybe.
No, I say because to be personally present in the court, because that will be my holiday for summer vacation starts in the month of May.
Okay. We'll see on the next date.
Yes, my lord.
You are waiting till 2014. We will also want to decide it.
Absolutely, madam. Madam, on that context, I will cite a judgment also that alternative remedy should not be a bar when a
No,
matter is pending for
That
so long.
is, I am always, that alternative remedy is a self-restraint on us.
Absolutely, my lords.
226 court, there cannot be any,
Why
nobody can say that you don't have the jurisdiction. That is our self-restraint.
My lord.
My learned friend is restricting my lord on that.
No,
This is my humble submission.
No, he cannot. He
I'm
cannot.
also submitting.
In a given case, even some,
Absolutely.
yes,
My lord, on a Thursday, Wednesday or Thursday, some
20, the second,
25 Tuesday.
23rd of
no, my lord, not on Tuesday, 24th or 25th.
22nd is a Monday. Keep it on
Tuesday.
Monday, no problem.
My lord, I request on a Thursday. Is it possible? I'm sorry.
I don't know. Maybe it's auspicious there.
No.
Then prior to that, what is
Hearing
the
day for
Thursday?
us. 23rd, 25th, 4th.
18th.
Yes, ma'am.
18th.
Yes, madam.
If necessary, we'll accommodate.
Yes, madam. 18th. Highly obliged, madam.
Yes, Mr. Kejriwal. Will not hear if it is a case for CAV. Case for CAV.
For if a demand was made after 33, the ground that the supplier were used by the energy bill was 1% of 10. The multiplier factor could have been 10, but they advertised they applied 1. Now the question is whether multiplier like 10, that is one of the second is that it was classified as a commercial unit, whereas the it was subsequently they have allowed. They took it there. They have allowed the petitioner to change this category. So all the bills which were issued, including the device, device. Third point is below. In terms of the features, they can take record to disconnect only in the aspect of smart, but a period of 2. Beyond that, they cannot take. They can take other remedies as available at both, but they cannot report. It has been held by that. And moreover, my lord, by virtue of the right of the electricity, right of consumer rules 2020, there is a special provision that is new. The respondent authority cannot issue any bill beyond any bill. The term is used any bill. So even if it is supplementary or subsidiary bill, they cannot issue after. Even if any bill is issued within 60 days, then they are supposed to grant rebate of 2 to 5.
Give a date auspicious.
Take it to 30th.
30th. As agreed to by the net profit. 30th of April.
Can it kept it?
No. I have forgotten Electricity Act.
No, your lordship,
Forgotten.
now only your lordship is there to hear these matters. Otherwise, there is a problem.
I have forgotten everything.
No, your lordship is aware about it. Obliged.
relating to violation of opportunity of hearing was afforded to me, and for that, Lordship, I have come to report against the order of assessment. Normally, Lordship, against the order of assessment, there is an appeal which for which you can go in merit. I have not come to this court on merit of the. I have come only on the ground that I want the matter to affect the same assessing officer because
What is their sense?
Paragraph 5.
Paragraph. Just a affidavit filed by
Respondent number 2, Arunima
45. Yes. Okay. Base.
Lordship here, inner page will be 2. Next page, Lordship.
Base 2. Base paragraph 5.
5.
Where is the provision and what is the procedure of issuance of notice?
any
Lordship, Lordship, can you tell you that it
1 3.
they were directed to submit the proposed notices here verification for it.
that we will time I will because Lordship that we are giving even only 20 like second the last week back. We have collected all the proposed notices. Everything is there. There are some more documents we need to collect. We will file the additional affidavit those documents. That's a different matter altogether. And
Are you having the record of assessment, any notice?
I will produce that. Lordship may pick up the small date and Lordship in the meantime Lordship I will go 2-3 paragraphs for your Lordship, which will make things clear and
Where is the assessment?
Lordship, the assessment is at page
Next sir.
Lordship, while making the assessment, Lordship, there will be many notices given prior to the assessment. They are Lordship, initiation assessment procedure. Assessment procedure starts with issuance of proposed notice. When was proposed notice given? That is the only thing which is important. Before that, they will ask to produce books of account. That is.
Wait, that's why I'm asking. Where is the provision of issuance of proposed notice under which provision?
I'll call Lordship only page 37. Lordship, the proposed notice is mentioned.
Page 37.
Page 37, third paragraph. And finally, earlier Lordship they issued me different type of notice. Final proposed notice.
This is the assessment order by which you are agreed that this has been passed without hearing me.
Without affording me a reasonable opportunity of
Okay.
reasonable lordship is a very important word. And finally, a so-called notice was issued.
Just
Why-
a minute, Tiller has submitted market return. Market return.
number of notices, not notice that assessment is start, but not the start of assessment. Finally, a so-called was issued. Wide number going for dated 18/12/2020 But my mistake was that this notice was received by me on 21st. Fixing the date as 29th. So 21st, if I receive a notice,
Now, when have you, suppose, okay, we presume that earlier notices and asking you whatsoever is forget about it. Now, final show cause notice was issued after their determination on 18/12/2014. You received that, and the show cause date of reply was,
29th.
with evidence was fixed on 29/12/2014.
So if I ask for document, that is what to be brought on for last day the court has ordered, bring that up. I ask for enjoyment. But if 7 days time, 20 received 7 days time was very
Where is
less
your
time.
statement here? In the petition that you have received on such and such date, and therefore you sought for an adjournment. Forget about the copy, we'll believe that.
But if in the case I have said that 10 days notice is fixed, because there is judgment in this effect, notice Lordship at least 15 days is to be given.
Okay, so as the judge, so as the judge.
Here, Lordship, the judgment is there by this honorable court division by judgment.
See, Mr. Chaudhary, it's pending since 2015, only for a small issue.
Only for
Yes, sir. Lordship will find it section 36 for it was initially taken for 40 assessment. They were given a opportunity. They
No,
They-
understand. You have, it is a
Then on the basis of
random
the-
assessment, is not it?
Yes, Lordship, and the C forms which they claim in their return, Lordship, those were verified from the state which were given, and it was found that they were fake. Then the rest of judgment will come into effect, Lordship, if they do not go for it.
So your case is that when we did this audit, selected for audit assessment under section 36, you found that these are all fake.
Yes.
So you issued a show cause notice. Issued a show cause notice. You have issued.
Yes.
They say that we received it on 29/12/2000. The date was fixed on 29/12. You received it on
21st.
21st. So the period was short. So they sought for an adjournment.
And in New Year holiday. And here the authority has passed a specific order also that I reject your prayer for it. After 7-8 days, I
Is
passed it.
it here on record? It is not.
That is
Okay, fine. For the time being, we believe you. So, that was rejected. Now, her second contention is that notice period should not be so small, from 18/12 to 29/12. So, as that any this notice, any state, any period is prescribed in that.
yes, your Lord. The
Yes.
period is prescribed under the Act.
What is the rule? What is the period?
Rule 25.
Is it as per the rule 25?
Lordship, the notice has notice, the prescription is given under.
Okay, what? No. Any time is prescribed in rule
Yes, Lord.
25.
The time is
Tell-
prescribed. Minimum 10 days. From the date of receipt. In fact, we some
Some better. These are not here.
from the
So according to you, this is a notice under section 40.
Yes, sir. But the
Section, it,
earlier was 40, this is 37.
Huh?
This is the 37 of assessment department, 35 to 40.
okay. Because
full
yes,
25
reassessment was done under 36.
Yes.
Now, after reassessment is done under 36, what is the procedure?
But if they are not passed an order, they are just started a audit
Audit assessment. So they under that audit assessment, they found that
some key forms.
you have been asked to product accounts documents, but you failed.
I paid.
Okay.
That date, within 7 days.
No, not on that.
Oh, yes, your lordship. The so
huh.
called
When they initiated the inquiry, they found some anomalies. They asked you to give certain documents. You were not there. Finally, they issued a notice under notice, show cause notice. But what is the provision of this show cause notice? I want to know. Because your judgment relates to section 40. What section 40 says?
turnover escaping it. But all the 36, 37.
No, let us have that.
That's what see the 36 under the proposed notice.
Okay, okay. $36, no? Audit assessment.
This is what they proposed. What they gave, what they finally assessed me under section 37. So, topic 36 is audit assessment.
No, 37 is base judgment assessed.
This is the order. This is under which they passed me the order. So 37 says, if any
Has not furnished any return in respect of period.
A to D things are there, which I presume that all these things I have done. The prescribed authority said, after issue of notice the trigger in the prescribed form in the prescribed, that is the so-called prescribed form in a prescribed manner, but to give it a reasonable opportunity. Assess best of this document, and lordship, for that we have form 21. This is the form 21 notice I have received. Form 21. Form 21 is also next.
Where is that notice?
Form 21 we find at page 872.
Just a minute. Just.
Even if it does not type, even if over the timing I
So this is assessment was done under 36. So notice is under 40. When any action done under 35, 30, 34, 35, 36 or 37, then notice is under 40.
and one more there. Even to give reasonable opportunity. The word is not opportunity. It's not just used so that I have given opportunity.
You are agree by which provision, which notice?
So I give reasonable opportunity. You are
No, there are two provisions of notice. One is under 40. One is under 36. 36 says that he will ask you, so you will submit this, that, but that notice has been given. Admittedly, you did not submit anything. So that there is no dispute. There is no dispute. So first 36 is gone.
not
Now, after 36, when they have not done, he has to, based of his judgment, assess, and now he is to give you a notice under section 40. Now, this notice,
section 30. Both are perimeter.
no, perimeter, but in your case, this action might have been done under 34, 35, or 36. That has been done. Now, after their satisfaction, they thought that we should give you a notice under section 40. Because under section 40, now this is accepted to present after giving dealer a reasonable opportunity of being heard and after making such inquiries as he considers necessary, proceed to assess the base of his judgment.
But this is what he-
No, we know that very important, but
if you
what is his finding that you have not in this order?
but if and then instead of sufficient time and dealer is in this part try to notice and fail to bring up and the and therefore he has passed a more specific provision of the act in there under section 36 penalty of which when levied through section 19 was mentioned in the notice of
Okay, we understand. Now, as a specific finding is there that sufficient time allowed.
but if reasonable opportunity has been given to whether this giving is a reasonable opportunity during that time. 21st December I received 29th I have to predict. But that's for time. That's not reasonable opportunity. That has also to be seen. When it is which is reasonable it's a very big thing that he is going to levy tax on me, rejecting everything of mine. Whether it is given opportunity of it has to be reasonable. If you reply for I will levy tax on you and penalty also. Tax interest he has levied on me and that amount of review. So at least he should give a reason for it. You have put other steps. So that was the have said that he is not matching with your team. So for that I talk to the dealer state. He has to give it time. I have to talk to the authority in that state. What is that he committed in that state. That has to match. And the match sometimes some figure which I give is not the figure which he gives. That is I have that's the very reason I could satisfy that this is the reason that we hold it. At least and what if finally is that I am dealing in ginger. Ginger is exempted food. I need not produce CFO. If I produce I have given it, the dealer has given it to me. But it's necessary for me to, so I have to give this for that he has to give a very reasonable opportunity. Levy tax for 5 years. For 5 years, he is levy tax on me and that also old period.
Okay, where is your statement regarding all this? In the
In the writ petition, I made statement and lordship.
Mr. Chaudhary, I think you decided to answer again. What is the meaning of keeping it pending here since 2015? It's for your benefit. There is a stay.
All in their court. Actually, it goes to them.
Where is your
levy tax.
statement? My idea was subject to what you say. Okay, she want a hearing. Let you be heard.
They already-
Lordship, if Lordship wants to remand it back, Lordship, that because since it's a old method, that instruction I have to take. Then in that case, Lordship may fix it on next Thursday.
What instruction?
So with regard to the remanding impact, because there are some of the assessment here, Lordship limitation will come into effect, subject to Lordship tax.
No, limit. Where is the question of limitation? It will relate back to the date of assessment. You will
Because-
hear everything on that day, demand everything, everything will be
If
applicable.
Lordship wants to remand it back, then Lordship may take it up on Thursday. I have the that part of
Thursday is a holiday.
next week. Lordship, it's a
Next week, Thursday is a holiday. Huh?
Not to keep it part of
So we will not keep it as a part hard. If Mr.
28.
See,
Yes, Lordship, I have answered.
see, if we say that she needs a reasonable opportunity of hearing could have been given, so everything will be decided on that day. It will relate back to that day. They cannot say that there is a limitation because of pendency. That cannot. If we say that they will be in difficulty in some other cases.
in the picture of it, that
But Lordship, here the 10 days period from the date of service. Lordship, when the
Just to tell us,
notice
we are
is
not
due.
deciding. Please tell us how much time will you require to file an object?
but 10
We
days,
or 10 days.
like that.
Exactly 10 days, then you can. This is our idea, and you bring that that you have file and because that is a if that be so, then it's a case for. But where is your statement?
Statement I made, but I made, and along with that,
We can take it up if this bench is to take it up. Then on we'll pass a simple order. We'll decide it. We can do it. When is that next? Monday is a holiday. Next Monday. Tuesday is a holiday.
Yes.
Wednesday and Thursday. These 2 days, it's
Thursday.
possible, not beyond that. Thursday?
Since Lordship has hired it, Lordship,
Because we have spend time, we'll decide on that.
Lordship,
Means tentatively, we are thinking of allowing this and remanding her back. But you, madam, you file and
that
bring that. Okay.
Sim-
So we'll simply adjourn it. List this matter on Thursday.
Third.
28 as part of it. Okay.
much of
Since we have that is
Yes, sir.
unnecessary spending here. It ought to have been allowed on the day one. Somebody wants to explain. Let him explain. Isn't it?
but by going by the rule
No, no.
25, Lordship 10 days from the date of, if going by the language, date of issuance 10 days. That's enough time. 18, 12, 29.
But the primary word used is a reasonable approach.
Reasonable. Lordship is the act has specified a
Defined.
period.
Okay, we'll see that. Yes. Which item is that?
Termination. Contract has been terminated. Now, two things for Lordship has asked. I was not present. So, the Lordship has said whether it's an academic exercise, one, and what will be the impact. Then my junior customer said that maybe they may blacklist. Then your Lordship said that we may protect you, they will not blacklist you of the term. But I think your Lordship, this court has decided my termination. Otherwise, that termination will always be. Only to the extent termination, but not to the extent of extending period is over. But they have taken an action. Whether termination issued by them on a very it's a small point.
But termination issued, is it require some disputed fact?
I will tell you a lot. Termination is based on a comprehensive policy under 20 point. Now, this is a contract ends. So within a period of 10 days, if you don't restart it, then it goes. Now, when they have taken action, it is taken action. The basis of the contract, that is termination. Termination is not 20.4. Termination is 21.1.
Okay, may not
So,
be possible.
yeah, that's why I'm saying, my lord, your lordship has to.
Sheets there, they want to argue with what this is.
So the period is over. For any further cause of action, it will be a new cause of action. Here already term is over and the impugn
So
order is
therefore, he
that
says
is
not.
only fair in the writ petition.
See, Madam Lucien, he says our view also more or less in that regard because contract is terminated, whether termination is good or wrong, there may be arbitration. Okay? Anyway, there are arbitration, so that can be decided. So we will not say we are powerless in 226 in a contract matter, but however, that is subject to certain qualifications. One of the qualifications are against this that we cannot decide a thing which are disputed, facts and need some
No,
factual asserts.
Let-
So you are saying that no, this matter is over, it cannot be. So to decide that also will require some time. Therefore, we are adjourning it.
No, that's why I'm saying.
No.
My lord, the disputed question of tax is totally different.
Huh?
But when you terminate, termination simpliciter, which has a civil consequence, then High Court can enter under defense.
Absolutely.
That's the only point,
That's why we are saying
not
that.
beyond that.
So whether we can exercise judicial review even after period of the contract is over to decide whether the termination was right or wrong. This is the issue. According to him, it is permissible. According to you, it is not. So we'll hear in some other. Whatever you have said, to uphold it, I'll have to write a judgment and hear him. Isn't it? That is what I am asking.
After taking.
After. Due to paucity of time, matter could not be taken up with this matter. Last week of